Hey, please, your lordship. Well, a sincere prayer for listing of a new matter tomorrow, my lord. It was filed in 3rd of September. In a MSC appeal, my lord, there is a delay, lordship has to issue notice on the delay on now. It's for tomorrow, my lord, if not in.
Okay.
And the second prayer, my lord, in item 12 of today's list, my lord, it is a hearing matter. I have the newly engaged standing counsel for the ASTC, my lord, and I have not yet received a file. May I pray, my lord, to take it up after the.
Have you informed the other side?
Well, I do not have the numbers of the other side.
Then you have to wait for.
Well, if my junior colleague appears, my lord.
Okay, we'll consider you.
My lord, I'm sincerely obliged.
Please, your lordship. I'm praying for a listing of a bail matters in this court. Your lordship,
Bail matter, no mentioning.
your lordship has rejected it, your lordship.
Now you pray before registry will list it before this court.
Your lordship have already paid before the registry. The issue is like this. The petitioner, his mother expired, your lordship, on 12th. And today is the third day.
When have you prayed before registry?
Yesterday itself, your
What
lordship.
registry has?
Registry said that I have to make a mention before this honorable court.
Why?
I went yesterday after filing the case. I made a mention before the judicial register with an application.
Okay,
The honor has said me to make a mention.
okay, when do you want?
Today, your lordship, because this is the third day, your lordship, his mother is expired. Otherwise, I would not have paid, your lordship.
At
I have
2
annexed
at 2 p.m.
I'm deeply obliged, your lordship. I'm deeply obliged.
My pleasure, lordship. Lordship, item number 1, lordship, and in this case, lordship, the for sole respondent, lordship, I have filed the Wakalatnama, lordship. And one more time, lordship, I have tried to communicate with him, lordship, but
Who is for the
petition.
item number 1? No necessity of mentioning. You can. It will be the next matter.
Lordship,
Wrong practice.
lordship.
May it please, your
Yes.
lordship. Item number 25, my lord. I'm for the petitioner, my lord. Hearing matter, my lord. I've taken consent from the opposite party, my lord. The matter may be adjourned for 2 weeks, my lord.
You are for the petitioner.
Lordship.
What is your name?
VK Borwa, my lord.
Heard Mr. V.K. Burwa, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. He submits that he has informed the counsel, learned counsel for the respondent regarding his prayer for adjournment, who has no objection to the said prayer. Stop. Hence, the prayer is allowed.
So, there is an interim, my lord. It may continue.
The interim order shall continue till next day.
Highly obliged.
My lord, I will to request to this honorable court, maybe please list on MSc appeal and RFA, and there is two other IA, which was long pending, my lord. So there are two MSc appeal and
fresh listing.
RFA.
Fresh listing.
No, my lord, it was on final stage for hearing, my lord. Final hearing is well. So maybe
Next
this,
week,
I have-
next week on a date to be fixed by
It
registry.
means on, my lord, on 29th.
No, next week on a date to be fixed by registry.
Next. Just my.
With regards to item number 26, lordships. 26. In this case, we have filed a cross objection yesterday, lordships. So the cross objection may be listed today, lordship, along with item number 26.
Okay.
Yeah, I please your lordship. Lordship, in a FAO matter, we filed an injunction petition on the year of 2023. It is a long pending matter, lordship. Kindly fix this matter on next week.
You have filed an injunction application.
Yes. On FAO 75/2023.
Okay, next week on a date to be fixed by registry.
Highly obliged.
May it please, your lordship, I beg to mention item number 17, my lord. With the
Once, 17.
Yes, my lord. With the consent of the other side, lordship may kindly be pleased to adjourn the matter for the day and fix it on lordship last week of October, my lord.
Heard Mr. D. Rathi, learned counsel for the appellant, who prays for an adjournment. With the consent of learned counsel for the respondent side, the prayer is allowed. Let this matter be listed in the last week of October on a date to be fixed by registry.
Much obliged.
May I please your lordship, with the consent of the other side, I beg to mention item number 19 and 20. I am for the appellant, my lord, insurance company. Appearing on behalf of Mr. P. Hazarika.
Lordship, I am for the claimant. Death may be fixed. Lordship.
What is your name?
SP Bora.
Heard Miss P. Bora, learned counsel for the appellant, who prays for an adjournment. on the ground of personal difficulty of the conducting counsel on medical grounds. Also at Mr. What is your name?
RK Mohan on behalf of AK Gupta.
R.K. Mohanto appearing for the respondent slash claimant. The prayer is allowed. Let this matter be listed in the last week of the October on a date to be,
First week of November.
first week of November on a date to be fixed by registry.
Applies.
If I may, my lord, I beg to mention item 18.
1-8,
Yes,
yes.
my lord, I have taken consent from the other side. My lord, the matter may be fixed on 11th of November,
11th,
man. 11 month. November, month.
why specific date?
My lord, we had discussed with the other side, that is the date. If it is inconvenience of your lordship, then
Heard Mr.
G Imtiaz, my lord, appearing for Mr. S. Ali.
G. Imtiaz, learned counsel for the appellant,
Respondents,
learned counsel for the respondent who prays for an adjournment. He submits that he has informed learned counsel for the appellant regarding his prayer for adjournment, who has no objection to his prayer. The prayer is accordingly allowed. Let this matter be listed on 11th of November.
deeply obliged.
May it please your lordship, I am for the, I beg to mention item number 13 and 14, lordship. I am for the appellant on behalf of Nilothal Das. Lordship, we have consent of the opposite party, respondent side. Lordship, may kindly,
My lord, in
Fix-
this matter, I am for respondent lordship. Lordship, they have accepted to accommodate today lordship. So kindly date may be fixed
Fixed.
lordship, because lordship, the matter was listed as per order of this honorable court lordship for early hearing lordship. Since 2 years back lordship, but since then lordship, either this way or that way. done it,
Heard.
lordship.
date may be fixed, lordship, Thursday or Friday, lordship. This month.
You will seek adjournment and you will also choose date. What court will do?
My lord, next week, hearing date lord. Only hearing date. Date will be-
What is your name?
NH Borvia lord.
Islam.
Heard Mr. A. Islam, learned counsel for respondent,
He is for appellant
Appellant
lordship. I am for respondent.
appellant. Also heard Mr. N.H. Borvia, learned counsel for respondent number 1 to 4. Learned counsel for the appellant seeks an adjournment on the ground of personal difficulty, to which learned counsel for the respondent does not raises any objection. Hence, the prayer is allowed. Let this matter be listed in
Twenty-third lordship.
no fixed date.
Lordship, otherwise it will not be listed lordship.
No, we'll fix a week.
Last week of this month. Maybe.
In the last week of this month on a date to be fixed by registry.
All right.
May I please, lordship? I beg to mention an RSA matter is pending since 2019, is fixed for hearing. It was last listed on 15th of September by order, but the item was deferred.
Pray before registry.
I believe, lordship, I beg to mention for listing on IA in RSL.
What I
ISC, lordship, in RSL.
relates to what?
Order. Lordship, mistaken order.
No interlocutory application in respect of what matter? Seek full instruction and then only come for mentioning.
May I please, your lordship? I would like to mention this item for withdrawal purpose, your lordship. Transfer petition 86/2024.
When do you want listing?
Your lordship, if possible, day after yesterday, tomorrow,
Okay.
16:10.
Okay.
May I please your lordship, I beg to mention a listing of a civil revision petition. At any date convenient to your lordship. This is a long pending matter. It is a 2019 case.
In which column? Which column? Hearing orders motion. First week of November on a date to be fixed by registry.
May I please, your lordship? My lord, I beg to mention this matter for orders. Very important is this, my lord. by an interim order, the execution proceeding has been stayed for 4 weeks. But or this order was passed on 19/8, so that has already elapsed. Anytime I may be evicted. So my lord, this may be taken 2 days unlisted. I was expecting that it will be listed today, but
No,
not
no,
listed,
no unlisted.
not listed today. But it should have been listed.
Day after tomorrow.
No, man,
You are-
tomorrow case
you-
is fixed, yeah,
When?
tomorrow, on
Then
15th.
why have you approached today? Because if we move it unlisted, the other side will not be knowing about this case.
Other side, perhaps not yet API. Notices, we have taken steps. Tomorrow, that
No.
is fixed there.
Notice has to go.
Notice is already sent by
No,
us.
unless it is reflected in the cause list, the other side may not be knowing about listing of the case. Therefore,
The interim order was passed at the
tomorrow,
motion.
tomorrow, tomorrow. Not today, tomorrow.
Tomorrow, that case is there. My lord. That's
No,
why-
that is your fault. We cannot give you relief on the back of the
No,
other side.
my fault is I was expecting today it will be listed better. What was holidays? So I was expecting it.
Why you were expecting listing today,
Because 4 weeks was there, returnable 4 weeks.
tomorrow? Yes.
Malad, his application was before the trial court, Malad, the plaintiff Malad filed a Malad amendment for amendment of the plaint as well as Malad affidavit in evidence sheet Malad. Only she page 52 Malad. Under Rule 6 2000, Rule 6,
Yes, Mr.
Order 6, Rule 7.
My lord, in this lordship, I was the engaged counsel lordship by another my colleague lordship. And he is dealing with the client lordship. But subsequently, he's not communicating with my friend and he's not also with me lordship. So my lord, I may be allowed to withdraw this here lordship. I have already informed lordship our team.
No, no withdrawal. We'll dispose of the matter today.
Lordship.
Yeah,
Lordship.
yes. You know the facts of the case.
No lordship.
Why you appear on the last date also?
Lordship, and on earlier occasion lordship, I have also made my similar submission lordship.
Earlier, for 3 occasions,
But
Malad,
only-
non-appearance Malad. Though his name is reflected in the cause list Malad. 6494 and 307 to 2025.
Yes, what is your case?
My lord. The petitioner as a plaintiff, my lord, filed a title suit, my lord, before the civil judge Borpeta, my lord, for specific performance of contract, my lord.
Yes,
And thereafter, my lord, notice was issued and my lord, the defendant side filed written statement, my lord. And plaintiff, my lord, kindly peruse, my lord, annexure 1, page 12. And thereafter, my lord, written statement, my lord, page 19, annexure 2. And thereafter, my lord, evidence in chief, my lord, was filed, 4 numbers of evidence in chief, my lord, filed by the plaintiff side. And thereafter, my lord, the plaintiff filed, my lord, petition under Rule Order 6, Rule 17, my lord, page 52, my lord, annexure 4. Seeking amendment of plain, my lord, as well as, my lord, evidence in chief, my lord.
you filed the
My lord,
amendment
My
petition.
lord. And my lord, that petition was rejected by the, my lord, trial court, my lord. Annexure 6, page 66.
Yes.
my lord, operative portion mildly kindly see, my lord, page 70, my lord. Page 70,
Yes,
may I read, my lord?
yes.
Second line, the suit is at the stage of cross-examination of PWs. Already on the basis of suit, the defendant have submitted their written statement. Further, if the proposed amendment is allowed to be made, it will change the facts which are already pleaded by the plaintiff regarding oral agreement for sale. Even the documents which are sought to be fixed are not a part of the original suit of the plaintiff, which in the view of this court will cause prejudice to the defendants. In the suit, already evidence on affidavit is filed by the petitioner plaintiff side. There is no mention in the petition why the proposed amendment has been sought, and same fact could not be introduced when the suit was originally filed by the plaintiff at the time of institution of the suit. Considering the nature of suit, therefore this court is not inclined to grant, therefore petitioner plaintiff as same shall cause prejudice to opposite party defendant. Hence prior petition so is rejected. My lord, the proposed amendment is regarding, my lord, the date of, my lord, execution of oral agreement. And second, my lord, the receipt of money, my lord, by the defendant, my lord, in 10 lakhs, my lord. Out of that, my lord, 5 lakhs, my lord, I have, my lord, given, my lord, through check, my lord.
Where is your petition seeking amendment?
My lord, kindly see, my lord,
Where is the
page
petition?
52, my lord, annexure 4. Page 52, my lord.
What was the reason you have mentioned that why you could not state these facts in the plaint earlier?
But it is not specifically not mentioned, my lord, but it is due to, my lord, oversight of the, my lord, plaintiff, my lord. Because, my lord, it
No,
is
but
a
where is,
date, particular date, my lord. It is the, my
where is
lord,
then how the impugn order is wrong? Impugn order has been passed amongst other on the ground that you have not stated reasons for not mentioning the same.
it due to fault of the, my lord, to concern advocate, my lord, but it, that, after, my lord, filing of the
So
evidence sheet,
why
my lord,
this court should exercise powers under 227 when there is no
But,
jurisdictional error, no error on the part of the trial court? Trial court, whether the order of the trial court is wrong, if it is wrong, on what count it is wrong, you have to state.
because, my lord, it is not never changed the, my lord, original suit of nature of the suit, my lord.
So you can seek
It is
any amendment.
typographical error, my lord, most basically, my lord. One date, my lord, month, date, my lord, it is, my lord,
Read order 6, rule 17.
my lord. May I read, my lord?
Yes.
The court may at any stage of the proceeding allow either party to alter or amend his pleadings in such manner or on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties, provided that no application for amendment shall be allowed after the trial has been commenced, unless the court comes to the conclusion that, in spite of due diligence, the party could not have raised the matter before the commencement of.
Where
the
is this
trial.
where is this in your petition? The second part, where is
Due
this
diligence, my lord.
due diligence? The trial has already commenced, evidence started. Where is the due diligence?
But it is not a cross examination, my lord. It evidence.
No, where is,
my
you
lord.
show your due diligence, I will allow your petition. Otherwise, it will be dismissed.
But it is not reflected in the petition, my lord.
Then you
But,
don't
my
have a
lord-
case.
But my lord, it is the typographical error, my lord, but it not never sends the, my lord, cause of the, my lord, text of the case, my lord.
Yes, Mr. Hawk, you want to make any submission?
On this regard, my lord, I have a citation, my lord, some. No petition,
No, before citation,
my lord.
to support which contention you are submitting your citation. You have not answered my query. Whether there was due diligence on your part, and in spite of due diligence, you failed to. There is no statement regarding due diligence in the
Petition, my
in
lord.
the petition. The revision petition is dismissed.
In this case, my lord, typographical error, my lord, it is.
I'll pass orders in chambers. This revision petition is dismissed.
I will do publish.
Oblige.
No, no, this first table we have filed against the impugn order that containing page 73, which date is still today, 14/10/2025. Now today is also the date fixed in trial court, my lord. Now today we are going to file our pleadings, everything there. Lordship, in terms of the order 39(3)(a), Lordship may kindly give a observation that the matter will be disposed of by the trial court within a period of 30 days, my lord. I don't want to pursue that matter of the case, right?
You are not pressing for,
No, my lord, because today is the last day of this order. And my lord, today is also date fixed for trial court, my lord. Today we are going to file our pleadings. Now only, my lord, because my lord, it's a ex parte order. In terms of order 39(3)(a), my lord, 30 days period is there. Also, may kindly give an observation that 30 days the matter will be disposed of in that.
yes. Heard Mr. S. Chamaria, learned counsel for the appellant. Also heard Mr. A. Khatonia, learned counsel appearing for the respondents. This application, this appeal under order 43 rule 1 within bracket R of the Code of Civil Procedure 1908 has been filed by the appellant Sunil Bajoria, impugning the order dated 19/9/2025 passed by the Court of Learned Civil Judge Senior Division number 1, Kamrup Metro, in Miss J case number 879/2025 in connection with title suit number 574/2025. Stop. By the impugn order, ex parte interim injunction was granted in favor of the respondent. Learned counsel for the petitioner, learned counsel for the appellant has submitted that the miscase in which the impugn order was passed is fixed before the trial court today only, and therefore the appellant does not want to pursue this matter. He only prays for an observation that the miscase in which ex parte interim order was granted may be disposed of in pursuant with the statutory provision within 30 days. Stop. Learned counsel, Mr. A. Khatonia.
P. Katuni.
Sorry. Earlier also P.
Senior counsel.
Mr. P. Khatonia, learned senior counsel, assisted by whom?
Actually, I am not doing this, not yet doing it. Only P. Katuni.
Mr. P. Khatonia also does not opposes the prayer as the petitioner, as the learned counsel for the petitioner is not pressing the matter. Stop. considering the submissions made by learned counsel for both sides, this FAO is hereby disposed of with an observation that the trial court shall make all endeavors to dispose of the Ms. J case number 879/2025 within 30 days as per the statutory prescription provided in the Code of Civil Procedure 1908.
From today, madam, because only one line floated for you. 30 days from.
30 days from the date of this order.
Deeply obliged.
IA in view of the disposal of the IA is disposed of. In view of the disposal of the first appeal, the IA stand disposed of.
May it please your lordship.
Yes.
Lordship, here the suit is a commercial suit. And the petitioners before your lordship are the defendants of the commercial suit. Earlier, my lord, it was filed as a money suit. Subsequently, it was converted and transferred to the commercial court and registered as commercial suit number 13/2022. My lord, after receipt of my lord notice, my lord, as the defendants have not received the copies of the plaintiff, my lord, the documents. Therefore, we have filed an application praying for furnishing the copies of the documents which have annexed with the plaintiff, my lord, on 26/9/2023. May kindly note, my lord, 26/9/2023, we have filed an application seeking copies of documents.
26/9/23.
23. Thereafter, my lord, after 8 months, my lord, they have submitted the documents before the court. And we have received it on 15/7/2024. That means, my lord, they have submitted on 8 months, my lord, after 8 months, and we have received on 15/7.
Why you received late? When
My
they,
lord, my lord, on that point, my lord, there is no quarrel, my lord. There is no dispute, my lord. It is not the issue, my lord. Supposing, my lord, we have received it on 30/05/2024 also. Then also my case, my lord, comes within the 120 days, my lord. Why I am saying so, my lord? Immediately after receipt of the, my lord, the copies, my lord, in a commercial suit, my lord, there is a requirement of filing the written statement within the statutory period of 30 days and maximum within the period of 120 days. That is the prescribed norms as per, my lord, Order 5, Rule 8. Order 5, Rule 1. Order 5, Rule 1. My lord, may for a moment kindly take up Order 5, Rule 1. Here, my lord, two my lord, provisions is involved, my lord. One is Order 5, Rule 1, and another one is Order 9, Rule 7, my lord. First, my lord, may kindly take up Order 5, Rule 1, my lord. It says, my lord, when a suit has been duly instituted, summon may be issued to the defendant. My lord, may kindly see the special amendment part, my lord, the star mark portion, my lord, the special amendment, where, my lord, it has been written commercial dispute of a specified value. In its application, lordship got it?
second proviso.
No, my lord. I am just pointing, my lord, that special amendment part, my lord. There is an amendment, my lord, in regard to, my lord, commercial dispute. In the Bay Act, my lord. My lord, below rule 3.
Below. No, below, yes, sub rule, my lord, order 1, order 5, rule 1,
Yes,
sub
yes.
rule 3, thereafter, my lord, special amendment, my lord.
Yes.
Commercial dispute of a specified value in its application to any suit in respect of a commercial dispute of a specified value in order 5 in rule 1, in sub rule 1 for the second proviso, substitute the following provisions, namely, provided further that where the defendant fails to file the written statement within the said period of 30 days, he shall be allowed to file the written statement on such other day as may be specified by the court for reasons to be recorded in writing and on payment of such cost as the court deems fit, but which shall not later than 120 days from the date of service of summons and on a expiry of 120 days from the date of service of summons, the defendant shall forfeit the right to file the written statement and the court shall not allow the written statement to be taken on record. So, my lord, the outer limit is, my lord, 120 days.
Okay.
Here, my lord, the plaintiff, my lord, the plaintiffs, my lord, submitted the documents before the court on 30/05/2024. And my lord,
30 or 26/9/2023.
26/9/2023, I have filed an application seeking the documents, my lord.
Okay.
And in response to that, my lord, as per direction of the trial court, they have submitted on 30/05/2024. So from the date of, my lord, 30/05/2024, from the date of submission of that particular, that documents, my
You
lord,
get 120 days.
yes, the 120 days will complete. That would expire on 27/09/2024. My lord, may kindly note, my lord, 27/09/2024, my lord, the 120 days would expire.
Yes.
My lord, I am not calculating from the date of receipt of that particular, that documents, my lord, that is from 15/7. I am calculating the 120 days from 30/05/2024.
Okay.
And the 120 days would expire on 27/09/2024. But my lord, what had happened, my lord, on 19/9/2024, the matter was posted for filing my written statement. And on that day, my lord, a default was caused on our party. Because of wrong posting of my lord, entry in my diary, my lord, I have failed to appear on 19/9/2024. And admittedly, my lord, on 19/9/2024, my lord, the 120 days was not completed. Because my lord, 120 days would expire on 27/9/2024. So, my lord, the trial court, my lord, ought not to have proceeded ex parte, but in spite of, my lord, they have the trial court proceeded ex parte and fixing the matter for filing of evidence from the side of the plaintiffs and fixing the matter on 27 on, my lord, fixing the matter on, my lord, 29/11/2024, my lord. So, my lord, on 29/11/2024, my lord, may kindly note, my lord, after, my lord, 19/9/2024, the trial court fixed the next date for evidence of the plaintiff side on 29/11/2024. On that 29/11/2024, the defendants have submitted their written statement. And along with that written statement, my lord, they have filed another application praying for under Order 9, Rule 7, my lord, praying for setting aside the order dated 19/9/2024
for proceeding ex parte against the defendants, my lord. So, my lord, on after filing of that, my lord, petition along with my written statement, my lord, the tribunal, my lord, they vacated, my lord, the ex parte order, my lord. But, my lord, the trial court did not accept my written statement. And therefore, my lord, the petitioners, my lord,
The ex parte order was vacated.
ex parte order was vacated, my lord, but my WS was not accepted. Lordship will find that, my lord, the order, my lord, that impugn order at page 42. Page 42 is the impugn order.
Page 40.
42, annexure 6. Lordship, I am reading date 21/02/2025. Both parties are represented, heard. The petition number so and so under order 9 rule 7 of CPC has been filed by the defendants with a prayer for setting aside order dated so and so passed against the defendants and accept his written statement filed on 29/11/2024. The contention of the learned counsel for the defendant is that on 19/9/2024, the defendants have failed to appear as the counsel for the defendant has wrongly posted or recorded the date as 25/09/2024 instead of 19/9/2024 in his diary due to bona fide mistake, and as such, the defendant stated that his non-appearance was not willful and not deliberate. On the other hand, the learned counsel for the plaintiff has raised objection stating that defendant has received the copy of the document furnished by the plaintiff on 15/7/2024 for preparing written statement. But the defendant failed to file written statement within statutory period of 120 days. And it is further submitted that the defendant cause shown by the defendant for his non-appearance is not reasonable. Well, here, well, they have admittedly, well, they said about 15/7, but I am not on that, my lord. From 36/2024 also, we are under 120 days. Now, upon hearing and perusal, it appears to me that the instant suit is a commercial dispute which is to be proceeded in an expeditious manner. It is mandatory to file written statement within a period of 120 days. In the instant suit, if the defendant is allowed to participate in the suit, it would help in proper adjudication of the matter. This is the observation, madam. Accordingly, considering the above, the prayer of the defendant is allowed and set aside the order dated 19/9/2024. However, this is the condition. However, written statement filed by the defendant is not accepted, but defendant is allowed to participate in the suit without filing WS. Fixed 17/5/2025 for evidence. So, my lord, here, my lord, order 9, rule 7 says, my lord.
No, but when you knew that the documents were furnished to you on 30/5/2024, that fact is known to you.
Yes, yes.
Then you know the outer limit,
Yes.
120 days.
Yes.
Outer limit would have been on 19/9, on 27/9/2024.
Yes. That is
Then
true.
it was on for you to approach the court within the, you missed one date, but you knew the earlier date.
No, but my lord, as the court has posted the matter on, my lord,
You should have,
29/11/2024, my lord.
but restriction is on the defendant. Outer limit restriction would be applicable to you. You should have, because it is not the case that you don't know what would be the outer limit. It is within your knowledge that 27/9/2024 is the outer limit of filing WS. You should have appeared and filed your WS.
I got your query, lordship. But my lord, yes, admittedly, my lord, on within that, my lord, 27/9/2024, my lord, we have not submitted our written statement, my lord. That is an admitted fact, my lord. There is no quarrel on it.
Because
But my lord, may kindly see, as the court has posted the matter on my lord, 29/11/2024, my lord. Therefore, my lord, we have approached this because, my lord, here, my lord, as the court has proceeded ex parte, my lord,
okay, okay.
if the court has proceeded ex parte, unless and until, my lord, the ex parte order is vacated, my lord, court will not accept
Yes,
this
Mr. Moria,
statement, my
what is the submission?
My lord, ex parte does not mean that there is any bar on him to file the WS with a prayer for vacate ex parte. My brother is saying that he posted the date on 25/9/24.
His main contention is that court on 19/9 ought to have fixed the next date on 27/9.
My lord, I'm coming on that. I'm coming on that, my lord. My brother is saying that he posted the date on 25/9/24 instead of 19/9/24. On 25/9/24, he appeared in the court, and on that date, he came to know that date was on 19 and not on 25/9. And he stated in his petition that on 19/9/2024 he could not appear because the date was posted in his diary as 25/9. But when he appeared in 25/9, even if that was not a fixed date, then also on that date also he could have filed
He
the
could have
WS.
filed. He could have filed, there was no bar. He
Yes.
could have at least made a prayer that accept my WS, otherwise outer limit would be crossed.
Yes.
Now, how much money is involved in this commercial suit?
Yes. It's 8,04,011.
How much cost will you pay for filing WS? How much cost you are ready to pay for your WS to be taken on record?
Lord,
Because 120 days is with cost is mandatory.
Lord, 2 to 5,000, my lord. As cost, my lord.
You pay 50,000
Lord, 50,000 will be, my lord, too higher, my lord.
because this is a
Because-
commercial suit.
My lord, that is true, my lord. But my lord may kindly appreciate one thing. my lord.
And
My
fault
lord, I
is,
am not.
you
on, my lord,
cannot take commercial suits like any other normal suits. Though in other suits also, the
my lord, your lordship is very correct. But my lord may kindly appreciate one thing. I am not praying for negative equality. My lord,
Negative?
no, negative equality. My lord, I am not praying for any negative equality, my lord. Like, my lord, the plaintiffs, my lord. My lord, let me, my lord, submit. my lord.
Negative
Why, my
equality
lord, why I am saying so, my lord? My lord, why, my lord, the 120 days is prescribed, my lord? So
That is-
that, my lord, the proceeding must be, my lord, expeditiously disposed of. That is the mandate of, my lord, framing the time limit of 120. Well, may kindly appreciate one thing. My lord, they have, my lord, if they are so much in hurry, my lord, they have taken, my lord, 8 months time to submit their, my lord, the documents, my lord.
it was also lapsed.
And, my lord, till date, my lord, they are taking time and time again and again, my lord. They have not filed their written evidence also, my lord.
Okay. Heard.
My
Mr.
lord, that is not the issue here. When earlier it was a money suit, at that time steps were taken along with all documents that were submitted.
No, I have not received any documents, my lord, along with the summons, my lord. Only the plaint, my lord. And that is very much clear in the orders of directing them to furnish the documents.
I furnished it, even if I furnished on 35/24, he has taken on 15/7, what he was doing for 1.5 months in that period, And there was no bar in filing WS, even if the date is not fixed on that date. On off date also, that WS can be filed.
Heard Mr. M. Datta, learned counsel for the petitioner. Also heard Mr. H. L. Moria, learned counsel for
All respondents.
all the respondents. This application under Article 227 of the Constitution of India has been filed by the applicants impugning the order dated 21/2/2025 passed in commercial suit number 13/2022 by the Court of London, Civil Just Senior Division number 3, Kamrup Metro, insofar as Kamrup Metro, stop. By the said order, the trial court rejected the prayer of the petitioner to take the written statement on record. Written statement which was filed on 29/2024 on record, mainly on the ground that same was filed beyond the time prescribed in the statute, time of 120 days, beyond the outer limit of the time prescribed, time of 120 days prescribed in
Order 5 rule.
Order 5 Rule
One.
Rule 1 of the Code of Civil Procedure. Learned counsel for the petitioner has submitted that initially the commercial suit number 13/2022 was registered as a money suit. However, later on it was converted into commercial suit. He further submits that though the summons were received by the respondent in the aforesaid case, in the by the present petitioner within bracket defendants in the aforesaid commercial suit on what happened on 26/9/2023.
No, my lord, on that day, my lord, I have filed an application seeking the documents. Direction there.
Karika. So, however, it was not accompanied with the documents annexed along with the plaint. And therefore, he submits that on 26/9/2023, the present petitioners filed an application before the trial court for directing the plaintiff/respondent, plaintiff within bracket respondent in this case, to furnish the documents annexed along with the plaint. Learned counsel for the petitioner submits that though the court directed the plaintiffs to furnish the documents to the present petitioner, however, the plaintiff submitted the documents in the court only on 30/5/2024. Stop. Learned counsel for the petitioner further submits that the case, the aforesaid commercial case was fixed before the trial court on 19/9/2024. Stop. He submits that on the said date, due to wrong recording of the dates of the said case in the diary of the counsel of the petitioner, the learned counsel for the petitioner could not appear before the trial court on 19/9/2024. Stop. Accordingly, the trial court fixed the matter Accordingly, trial court directed the matter to proceed ex parte against the present petitioner and fix the matter on 29/11/2024. Learned counsel for the petitioner submits that the counsel for the petitioner, the learned that engaged counsel, you were the counsel in that he had recorded the next date in his diary as 25/9/2024. And when he appeared before the court on the said date, he came to know that the case was already posted on 29/11/2024 for ex parte hearing. Stop. Learned counsel for the petitioner submits that on 29/11/2024, the petitioner had filed an application under Order 9, Rule 7 of the Code of Civil Procedure, along with the written statement, with a prayer to set aside the ex parte order dated 19/9/2024, and also to accept the written statement which was filed on the said date. So, however, by the impugn order passed on 21/2/2025, the trial court, though set aside the ex parte order, did not allow the written statement filed by the petitioner to be taken on record as same was filed beyond the outer limit of 120 days prescribed by Order 5, Rule 1 of the Code of Civil Procedure. Stop. Learned counsel for the petitioner has submitted that as the plaintiff had furnished the documents which were annexed with the plain before the court only on 30/5/2024, the outer limit of filing written statement, that is 120 day, would have lapsed only on 27/9/2024. Stop. He, however, submits that the trial court on 19/9/2024 fixed the next date on 29/11/2024, thereby depriving the petitioner with some additional days which he would have got had the case been listed again on 27/9/2024 instead of 29/11/2024. Stop. Learned counsel for the petitioner has submitted that as the outer limit of 120 days would have expired on 27/9/2024, the trial court ought to have fixed the next date after 19/9/2024 on 27/9/2024. However, he submits that though the written statement was ready with the petitioner, same could not be filed on 25/9/2024, when the learned counsel for the petitioner appeared before the court, as he came to know about the fact of posting of the case on 29/11/2024. Learned counsel for the petitioner submits that the trial court has rightly set aside the ex parte order passed on 19/9/2024. However, he submits that it erred in not taking on the written statement filed by the petitioner on record. Ignoring the fact that the outer time limit of 120 days would have expired on 27/9/2024. However, the case was fixed on 29/11/2024. He submits that the petitioner would be highly prejudiced if he is not allowed. How many petitioners are there? Petitioners would be highly prejudiced if they are not allowed to, if the written statement filed by them is not taken on record. Stop.
My lord, just I want to clarify only one thing in the order. He has not stated that on 25/9/20 his WS was ready. He has not stated. And WS is filed, that is on 29/11, that date is, not on 25/9.
You have not appeared on 25.
No, I have appeared, but my lord, when the date is not fixed, my lord, my Hazira, my lord, nothing is accepted. That is the
But you
problem.
have made submission that you appeared before the,
My lord, on 25.
on that day you came to know that it
Yes,
is
I came
fixed
to
on
know, my lord.
25/11. It is fixed on 29/11. On 25/9,
Sir, not ready by him.
Yes,
that noting you took in your case, in your diary.
yes, I have, my lord,
No, is it your submission that 19/9/2024 you defaulted because you took the date as 25/9/2024 in your diary?
yes, yes,
Therefore, you defaulted on
Yes, yes.
19/9.
yes, therefore I defaulted on 19/9, my lord.
So on 25/9, whether you appeared
Appeared, my lord.
and you
As
came to know that it is fixed on
fixed on 29/11.
29/11. Only that I have stated.
So, no, no.
Thing, my lord.
Then, but he has not stated that on 25/9/24 he had, the WS was ready, and
Yes.
for that reason he could not file.
Oh, that
It is
This,
complete.
But my lord, once
this-
an order,
I'll delete that. I'll
Yes.
delete that.
In his petition, he has not mentioned that.
Yes, I'll delete that.
but my lord may kindly appreciate one thing, my lord. Once an order 9 rule 7 is allowed, then
No,
my lord, I
that-
am
no,
relegated back.
He's
to-
on a different aspect. That is not stated. I'll delete that. On the other hand, learned counsel for the respondents has Mr. H.L. Moria has vehemently opposed the prayer of the petitioner on the ground that the suit in question being a commercial suit, and the statutory prescriptions clearly provides the outer limit of 120 days, which was within the knowledge of the petitioner. And therefore, the trial court, by passing the impugn order, has rightly rejected the
Accepted.
prayer for taking the written statement on record, written statement filed by the petitioner on record. Any other submission?
No.
Stop.
One more, my thing. Outer 120 days also, first only 30 days, then only one application that it can be extended. But there is no application from his side. On 25/9, there is no application for that. Even if he appeared on 25/9, that was not a fixed date, then also there is no bar.
No,
On there, he could have filed a petition for acceptance of WS.
stop. Learned counsel for the respondent has also submitted that even if the submissions made by learned counsel for the petitioner is accepted to be true, still the date recorded by him in his diary, that is 25/9/2024, was within the outer limit of 120 days for filing written statement. And on that day, he could have filed an application before the trial court for accepting his WS. However, same was not done. And therefore, he submits that trial court has correctly rejected the prayer for accepting the written statement. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. The special amendment in respect of special amendment brought in respect of commercial suits to Order 5 Rule 1 clearly indicates that the time limit for filing written statement would normally be 30 days. However, for reasons recorded in writing and on payment of such cost as the court deems fit, the defendant may, in a commercial suit, be allowed to file written statement from 120 days, written statement within 120 days from the date of service of summons. It also clearly mandates that on expiry of 120 days from the date of service of summons, the defendant shall forfeit the right to file the written statement, and court shall not allow the written statement to be taken on record. In the instant case, it appears that in spite of the directions of this court, of the trial court passed on 26/9/2023 to furnish the documents to the petitioners, furnish the documents annexed with the plaint to the petitioner. Same was done after a lapse of 8 months by the respondents, which has caused delay in the aforesaid commercial, delay in progress of the aforesaid commercial suit. It also appears that the the summons served on the petitioner were not accompanied with the documents which were annexed along with the plaint. And therefore, the date of effective service of summons may be regarded, date of effective service of summons for the purpose of filing of the WS may be regarded as 30/5/2024 in this case, when the documents annexed along with the plaint were furnished in pursuant to the direction of the trial court. Stop. It is also a fact that the period of 120 days from the date of furnishing of the documents, that is 30/5/2024, would have lapsed only on 27/9/2024. However, the trial court had fixed the commercial suit on 19/9/2024. 19?
No, Lordship, 29/11.
No, 19/9/2024. That is 8 days prior to lapse of the outer limit of 120 days. And the next date was fixed again on 29/11/2024, which is beyond the period of 120 days prescribed by the law. Though the court cannot be held to be on wrong side by fixing such a date beyond the period of 120 days, but it has certainly deprived the petitioner of additional 8 days for filing the written statement. Filing the written statement, within the outer limit of 120 days. Stop. This court also agrees with the submissions made by learned counsel for the respondent that as the outer limit of 120 days prescribed by the laws was known to the petitioner, they could have approached the court on any day after 19/9/2024 and before 27/9/2024 to file their WS. Stop. File their WS. Stop. However, as same was not done, the trial court cannot be held to have erred in rejecting to take the written statement filed by them on record. In the instant case, the case, had the trial court fixed the next date on 27/9/2024 instead of 29/11/2024, the petitioners could have filed their written statement within the prescribed time. It also appears, it is also to be taken into consideration that this aspect was not taken into consideration by the trial court while passing the impugn order, though passing the impugn order stops, though, it has allowed the petition filed under Order 9, Rule 7 for setting aside the ex parte order dated 19/9/2024. Stop. 19/9/2024, this court last line पढ़िए तो. Stop नहीं, comma दो. Stop. 19/9/2024. Stop. This court is of considered opinion that as the stakes in this commercial suit is to the tune of rupees 18 lakhs,
8 lakhs, 4,000,
8 lakhs 4,000,
11 rupees.
1,100, to the tune of approximately 8 lakhs. The
Interest 24%. They are claiming.
the trial court would have considered the fact that after 19/9/2024, it fixed the commercial suit on 29/11/2024. That is beyond the period of 120 days. And thereby the petitioners were deprived of additional 8 days of the outer limit for filing the written statement in pursuant to the provisions of under Order 5, Rule 1 of the Code of Civil Procedure.
My lord, 8 days could have been provided them only if there would have been an application for that. So if the party does not appear, then the court has no option to only to fix the case ex parte. Because they had already appeared on the earlier dates. On that date, they were not present. So in absence of the party, the court has no option but to fix the case for ex parte property.
Stop. Apparently, there appears to be no error in the impugn order passed by the यहाँ स्टॉप कर दीजिए. I have to frame I am allowing the petition with a cost of rupees 20,000.
Keep my lord.
No, this is commercial suit.
Mean, my lord, problem is that, my lord, this petitioner, my lord, he is presently, my lord, the bedridden, my lord. He
No,
with an
you
severe
have
road
to take
accident, my lord.
commercial suit in the
My lord,
spirit of
it was
commercial.
10,000 cost, my lord.
No.
Because I have to, because it was
I have declared my,
it was my fault actually, my lord, before that, my lord. Wrong posting of diary. because of- And he has bedridden. due to
Carry
a
is notes
severe
onto
accident, my
the,
lord.
carries notes onto the court also. Like,
Diary I can show.
remaining part I will declare in chamber. 20,000 cost, the petition is allowed.
My lord, it be 10,000.
No.
But
Otherwise, there will be
bedridden, my
no
lord,
difference
because he
between
made me-
commercial suit and ordinary suit.
Yes, that is. there.
okay.
May it please the Lordship. Lordship, I have filed this case after that some error was there and it has been corrected now, Lordship. Lordship, in this case, I am the defendant in the case, Lordship, the title suit. The DW one was, I have deposited the DW one and then the DW one was also cross-examined. After that, Lordship, I took several adjournments, Lordship. And on that very particular days, that is on 4/3/2020, I had filed an application for adjournment, which was not allowed. Frequent to that, Lordship would find that, Lordship, impugn that order, Lordship, in page number 28, Lordship.
Now, where is the impugn order?
Page number 27, Lordship. In the petition 394 filed on behalf of the defendant praying another date for DW showing cause that senior engaged counsel for defendant have gone outside due to his personal inconvenience and defendants are unable to communicate with him. Heard the learned counsel and perused the CR, which reveals that the defendant has already taken all adjournments for DW. It also appears that the defendant were specifically directed to produce the DWs, but the same is not done. Moreover, grounds shown by the defendant also found not satisfactory to further adjourn the case. Hence, the petition is rejected and DW is closed. Defendant shall deposit the earlier cost on the next date without fail, fixing 18/3/2020 for arguments.
18/3/2020.
Lordship, actually what has happened in this case, Lordship,
Now, what is the status of the suit?
that's what I'm coming to, Lordship. After 2020, the Munsif was not there. It was vacant. Subsequently, after the COVID, that pandemic thing, Lordship, there were two Munsif. Instead of one, there became two Munsif posts. Civil Judge number 1 and Civil Judge number 2. Now, we have filed a review application. After the case was transferred to another court, that is Munsif number 2
Where?
in Bilasipara only.
Okay.
Then we filed a review petition there, and the review petition was rejected recently, Lordship. That Lordship would find in page number.
Review for reviewing this order.
Yes, Lordship. That was rejected, and that is in page number 36. Now, Lordship, with all, Lordship, I would like to make a fair submission. There has been some lapses on my part also, Lordship. Lordship, I would humbly pray that I would be given one chance to adduce my evidence, Lordship, and if required, I'll pay cost also, Lordship.
What was the cost, total cost still pending, which you have not yet paid?
2,000.
How much?
2,000. And all the while, the Munsif was vacant, Lordship. The court was vacant, Lordship.
What for this suit was filed?
Lordship, with regard, that is the right title interest over 4 bighas of land.
Who is in the possession?
Lordship, I will just.
Now, at what stage the case is pending
For argument.
for argument?
from 2020 itself.
State is also,
I have nothing against the state lordship. That is, I have made them a party because
and notices have not yet been,
lordship, what has happened, lordship, it was supposed to be allowed, lordship, but because of my mistake, lordship, that
how can you say it was supposed to be allowed?
lordship has dictated, that the order was dictated, lordship, but because of that defect in my cause title, actually, lordship, that was not passed, and the civil judge number, that was a difficulty, lordship. One was civil judge junior division and another was civil judge junior division number 2. Because of that, lordship, I have filed IA also for correcting the records, and subsequent to that, again, I have went to the registry and then corrected it, lordship. Because of these confusions, lordship, was
who is in possession of this suit? Suit is for recovery of possession or
I think from the suit is in possession of the plaintiff, lordship. Because in page number 18, they are seeking a permanent injunction restraining the defendants from dispossessing the plaintiff from the suit. So in all probabilities, the plaintiff is in possession, not me, lordship.
heard Mr. P. Deka, learned counsel for the petitioner. Also heard Ms. D. D. Burman, learned additional senior government counsel appearing for respondent number 2. What to do? Should we issue notice?
Lordship, anyways, this matter is, lordship may kindly dispose of the matter.
How much cost will you pay?
Lordship.
You have to pay cost to the person who is not appearing on and on whose back we are passing this order.
Lordship, I will pay cost, lordship, because I admit that there has been some.
What is outstanding cost?
2,000 rupees.
Add 7,000, 8,000 to that.
Lordship, it will be. I have no idea about the financial status of the defendant, lordship.
Okay.
Lordship, you make it another 5,000.
This application under section 227 of the Constitution of India, read with section 151 of the Code of Civil Procedure 1908, has been filed by the petitioners, namely Usob Ali, Ramjan Ali, Sainuddin Ahmed, impugning the order dated 16/12/2024, passed by learned civil judge within bracket junior division number 2 Bilasipara, whereby the review application filed by the present petitioners in Ms. J case number 96/2022, entitled suit number 90/2020-2015, was rejected by the review application filed by the by virtue of the review application filed by the petitioners under order 47 rule 1, read with section 114 of the CPC. The petitioners had prayed before the trial court for review of the order dated 4/3/2020. By the said order, the trial court had by the said order within bracket, by the said order, passed on 4/3/2020, the trial court had rejected the adjournment application filed by the petitioners as defendants in the said suit and had closed the defendant's evidence. Stop. Learned counsel for the petitioner has submitted that though the order which was reviewed was passed in the year 2020 and the evidence of defendant was closed. The trial could not proceed further due to absence of the presiding officer for a long period. And thereafter, one more Court of Civil Judge Junior Division was,
Kindly say that the case was transferred to another court.
and thereafter, the case was transferred to Civil Judge Junior Division number 2, Vilasipara, before which review application was filed. Learned counsel for the petitioner has fairly submitted that is there any error in the impugn order? That fairly submitted that the impugn order may not be regarded as an erroneous order on any count. However, if the petitioners are debarred from adducing evidence within bracket defendant's evidence in the suit, they would be highly prejudiced. Learned counsel for the petitioner also submits that there is already an outstanding cost of rupees 2,000. Is it 2,000 or more? 2,000 to be paid by the petitioner before the trial court, and he is ready to pay any additional cost if his prayer is allowed for the ends of justice. You have any submission?
On the lordship, there is no error on FIR number taken.
Learned senior government, learned additional senior government counsel has also submitted that to invoke the jurisdiction of this court under Article 227 of the Constitution of India. There must be some error which is apparent on the face of the record. However, same is not the case in the instant case. Stop. I have considered the submissions made by learned counsel for both sides. When is the next date fixed?
I think last date was before vacation. Next date, Lordship, I'll intimate after 10 minutes. Lordship.
Okay. Learned counsel for the petitioner has submitted that. No. I have considered the submissions made by learned counsel for both sides. Considering the honest submission made by the petitioner, made by the learned counsel for the petitioner, that the impugn order may not be regarded as erroneous on any count. Erroneous on any count. However, as the whether argument has been,
No. Because the pendency of, we are filing petition saying that this is pending.
as the trial has not yet proceeded beyond the stage when the impugn order was passed, this court is of considered opinion that ends of justice would be served if the petitioners are allowed to adduce their defense evidence. Petitioner are given one last chance to adduce their defense evidence, subject to payment of some compensatory costs to the plaintiff, that is respondent number 1 in this case. In view of above discussion, this revision petition is disposed of without issuing notice to the respondent number 1, with a direction that the trial court may give one last chance to the petitioners to adduce defense evidence on the next date fixed, whenever next date fixed, on the next date fixed in the title suit number 90/2015, subject to payment of rupees 5,000 to the plaintiff by the present petitioners. It is made clear that the petitioner shall, in addition to the cost of rupees 5,000, will also pay the area cost of rupees 2,000, and the payment of cost shall be condition precedent for reducing the evidence by the reducing the defense evidence by the petitioners in the aforesaid title suit. If the petitioners fail to adduce the defense evidence on the next date fixed, the trial court shall be at liberty to proceed with the suit in its normal course to its logical conclusion. With above observation, this civil revision petition is accordingly disposed of.
My e-court statement, Lordship, for today is 14/10/2025 is for order, fixed for order. Argument, I think already over.
No. Necessary orders.
Necessary. 15/9 is argument, then today 14/10/25 is for order.
Okay, next date we are giving one chance. If they
Lordship
fail,
may fix a date because 14th is today.
Today is the 14th.
Today is 14th, so I will not be able to adduce evidence today, Lordship. So Lordship may fix a date.
no, how we can fix date?
No,
It
for-
is the domain of this trial court.
Lordship, I'm just seeing, Lordship.
It is ওপৰত এক line দি দিব লাগিব. I will show you where to insert. It is submitted at bar that the Title suit number,
So today is the hearing date, Lordship. Today.
title suit number 90/2015 is fixed before the trial court.
Lordship, the order of last week's order, I'll just read out. Both sides are represented in petition 829 of 2025 filed by the defendant's side praying for another date to submit certified copy of the order of Guwahati High Court. A prayer is allowed. Defendant is directed strictly to submit certified copy of the order or status quo order of Honorable
Okay,
High Court in the
okay,
next date for
okay, okay. Before today itself. Today itself. So the defendant on the next date, today some date will be fixed.
Yes.
On the next date, you will have to
Yes.
adduce evidence. Remaining will remain same.
Item 5.
Earlier, please, Lord.
Lordship. In this case, Lordship, the petitioners are the third parties, Lordship.
Third party.
Yes, Lordship. In this case, what happened, Lordship, they have filed one title suit that plaint I have annexed in page 55, Lordship. This is a suit against the decree holders, Lordship, Rabia Khatun. And after filing this suit, when they filed written statement, then we came to know that already they obtained a decree in the year 2020. The present petitioners are plaintiffs here, Lordship, page 55, annexure 6.
Just a minute. This suit was filed, has been filed by whom?
By the third parties, Lordship.
No,
In
no,
the
this 80.
80, Lordship, by the third parties, Lordship. We are the third parties in a earlier decided suit, Lordship. So when we
No, no,
file this
No,
suit
no, I'm not getting it. Title suit 80 has been filed by
by
some
the
other
petitioners, Lordship, by the
by you.
petitioners, the third parties, Lordship.
Third
Yes.
party in which suit?
In the earlier suit, Lordship.
Earlier means 80.
No, Lordship. That is
In 80, you were the plaintiff.
plaintiff.
And who is the defendant? Some
Earlier
other.
suit is 43/2017, Lordship. Already decree was passed in that case, Lordship. We were not aware when we filed this title suit, Lordship, 80/2021.
Title suit 43/2017.
Yes, Lordship. I'm coming to
Mm.
that, Lordship. Just I'm saying that we have filed a title suit 80/2021 against some defendants, Lordship. And the defendants filed their written statement, that is page 63, annexure 7.
Yes.
And in that written statement, page 73, they have stated about the earlier suit, Lordship.
In para?
11, Lordship. I was. Basically, they have
Okay.
stated that already they
The
have
suit was for right title in interest.
and recovery of possession
Possession.
against some other persons, Lordship.
In
Their
respect of
case-
the same suit
same
land.
suit of land.
Okay.
So
Then
they
you
are-
came
they-
to know about the pendency of an earlier suit.
Yes, Lordship. Already the Lordship judgment was delivered and your Lordship will
In
find
the
this-
earlier suit in 43.
Yes, Lordship. And your Lordship will find this written statement was filed on 25/10/2021, page 75.
Yes.
Written statement was filed 25/10/2021, Lordship. The date is very important. For that only I am pointing this date, Lordship.
Yes.
Now, Lordship, when we came to know that there is already another suit, Lordship, and judgment was delivered in favor of the defendants, then we inquired and we came to know that execution already also filed on the same date, 25/10/2021. So we have filed one objection petition in the suit, Lordship. in the execution proceeding. That is our application page 49, section 47 petition we have filed.
Page number?
49, Lordship. That was registered as Midje case number 22/2022 in title execution number 10/2021.
Who is in possession? You are in possession.
Yes, Lordship, as per our contention, we are in possession. As per decree holder's contention, Lordship, the judgment debtors are in possession. So, Lordship, accordingly, we are the third parties in the earlier suit. So my suit is pending, my suit is going on, Lordship. But
Your seat is for what relief you are seeking in 80?
Lordship, that
Title suit 80.
80, Lordship. That is, your Lordship will find page 60. For a declaration that the plaintiffs have every right title interest in the suit length, for a declaration that the defendants have no right title interest in the suit length, for a declaration by issuing precept to the circle officer Srijangam Revenue Circle by to mutated the name of the plaintiffs in the suit length on the basis of registered sale deed number 3423/1968 by deleting the name of the defendants from the suit length under Rule 118 of ARR 1886. Our case is that, Lordship, we have
No
purchased-
relief regarding possession.
No, Lordship, we are in possession.
Okay.
Our case is that, Lordship, the defendants are the original owner. So we have purchased in the year 1968, but as the original deed was, Lordship, by some fire or something, it was misplaced, so we could not record our name. When the defendants' names were recorded, they were trying to, they are threatening, Lordship, with the possession of the plaintiff, so that suit was filed, 80/2021. And when we came to know that 80/21, they have filed written statement stating that already there was a suit which was decreed in their favor. And when on 25/10/2021, Lordship, they have filed written statement as well as the execution proceeding, Lordship. That I have mentioned in my.
But defendants are different in execution proceeding.
Three parties, Lordship. We are third party in the earlier suit. In my suit, we are the plaintiffs, Lordship, that they are defendants. Those defendants were decree holders in the earlier round of litigation, and third parties are also there, Lordship. Means judgment debtors are also there.
Who is the decree holder in
Earlier suit, Lordship.
title suit number 43?
Decree holders are the defendants in my title suit, Lordship.
Okay. So the written statement
They have filed.
as
they
well
say
as execution proceedings
on the
have
same
been
date,
by the same person.
by the same person.
Okay.
On the same date they have filed, it is reflected in my objection petition, Lordship. Though I have not enclosed the execution petition, Lordship, but it is reflected in my objection petition that on 25/10/2020.
Okay, now what happened thereafter?
Thereafter, we have filed this application, Lordship. Only mistake the third parties have done, Lordship, they have not enclosed the purchase deeds along with this application. And on that ground only, the executing court rejected our application, Lordship. That is the impugn order, annexure 9, page 84. The petitioner's third party has filed a petition bearing number so and so under order, under section 21, rule 97. It ought to be order 21, Lordship. 98 and 100.
No, if you don't file your title deed, how the executing court
My
will come?
limited prayer is that otherwise, Lordship, this order is appealable, Lordship. My limited prayer under 227 is that, Lordship, some protection may be given to the petitioners to adduce those sale deeds before the executive court by another application, And after, as because lordship executing court is the competent authority to decide the right title interest
But
of
that miscase has been disposed of.
disposed of. For that only I have filed this CRP IO lordship. That disposed of not on merit, only on the ground that your lordship will find page 86.
Yes, you have not adduced any
Yes,
title
lordship.
deed.
On this paragraph, I have also gone through the petition, written objection and the case record of title suit number so. In this instant petition, since the third party petitioner failed to submit any registered sale deed to prove their title over the suit land, hence this court has not found any merit in the petition bearing number so. Accordingly, this petition is rejected. For that, I have already enclosed the sale deeds with my CRP IO lordship.
Yes.
I am for the decree holder. Your Lordship. See, my submission is this, that this is a ploy to stall the decree. I'll show how, your lordship. Initially, now coming to their petition, your lordship. Their petition is at annexure
Your petition was under what provision?
section 47.
47, lordship, section 47, page 49.
It is at page 49, your lordship.
And lordship, in my petition, I have stated that they have filed execution petition only on 25/10/2021. And judgment was delivered on 21/12/2020. I have enclosed annexure 1, page 15, lordship. But they have not filed any execution. When I filed the title suit for claiming right title interest, then only they have filed the written statement as well as the execution proceeding, lordship. Page 15, your lordship will find the judgment of the earlier suit, lordship. That is 21/12/2020.
But what is the error in the impugned order?
Impugned order, lordship, I am only praying for to reconsider the petition of the petitioners, giving liberty to adduce the sale deeds. I have enclosed the sale deeds with my petition. Your lordship may go through this. The sale deed number 387, annexure 3, page 36.
Lordship, if I may submit, your lordship.
Yes,
Coming to their petition.
just a minute. Page 36.
Yes, lordship. Sri Moniruddin Sarkar sold the land to one Rasmandal. And Moniruddin Sarkar is the predecessor of the decree holders, lordship. So our vendor is Rasmandal, lordship. He purchased from the predecessor of the decree holder.
This is registered sale deed.
Yes, lordship. The original is at vernacular is lordship at page 39.
But why you failed to annex it?
Lordship, your lordship knows they have just filed the petition stating the entire facts, lordship. In the petition itself, it was stated that we have purchased through registered sale deed. And our purchase deed also I have enclosed, lordship, that is the second one. Annexure 4, page 42 is the translated copy, lordship, and original is at page 45. Abu Bakr Siddiq purchased from Rosmondal.
When you filed order 47 petition,
5/7/2022.
so for 2 years you could not produce it was pending before the executing court for 2 years,
The two impugned order was passed on
24.
24, lordship. I have, the executing court could have asked for the registered sale deed, lordship. But there was no such plea taken by the respondent also.
No. Your petition was fixed for hearing.
Yes.
At the time of hearing, it was,
Registered sale deed, no one
but
questioned that.
it was your duty to produce the
That I
evidence.
understood, lordship. For that only I am before your lordship under 227 praying and to consider the petition of the petitioners, reconsider the petition of the petitioners by giving liberty to adduce the registered sale deeds, lordship. Only that much. Only a chance may be given. Already I have enclosed the registered sale deeds before your lordship. In prima facie, it shows that we have purchased through a registered sale deed from Rosmondal and Rosmondal
No,
purchased.
but under 227, the court would interfere if there is some error in the
that only, Lordship, I'm citing one decision which says the executing court has to decide the third party's rights, Lordship, by giving chance to the parties by calling evidences from the parties, Lordship. But that was not done. It's only in a single paragraph, the executing court said that.
No, before this, we have the records of title execution 10? What was the proceeding, whether chance was given to you or not? How will
Lordship,
we know?
That can be. But Lordship, execution proceeding was not stayed by while issuing notice, and the learned executing court is giving date to produce the stay order from the Honorable High Court, Lordship.
Yes, what is to be
Lordship.
done?
Page 15 is the decree that is in my favor, Your Lord. And
Yes, that she is
and-
also admitting that
That she is
decree is in your favor,
this was not against her, this was against certain other persons, Your Lordship.
but they are claiming to be in possession.
Now they are claiming to be in possession.
Yes.
Now in page 15, Your Lordship, it starts from page 15. If I come to page 23, Your Lordship, the defendants of the suit filed by me, Your Lordship, page 23, there was an issue. Issue number 3, Your Lordship.
Yes.
Whether it was alleged by the defendants in that suit, Your Lordship, the suit filed by me, that my predecessors, the plaintiff's predecessor, had sold out this land to certain other people. But this issue was decided, and even in that suit, these sale deeds, though alleged, were not produced. This was a suit of the year 2017
No, but that was by some
by some other person.
other defendants.
That was a defense taken by some other defendants in their favor. They were not a party to the suit, saying that the suit land was already sold out to
To them.
XYZ. To some other people. They have taken the stand, Your Lordship,
Okay.
not specifically naming them. Now, when the decree was passed, Your Lordship, in the year 2020, in 2021, I filed the execution. They filed a separate suit, Your Lordship. And when they filed the separate suit, claiming possession over the plot of land, because it is a kheti land, Your Lordship, it is an agricultural land.
Yes.
So the possession as such is not that concrete, Your Lordship, who is cultivating over it. Our suit was for declaration of right title interest and eviction of the defendants, Your Lordship. Now in 2021, after the decree of 2020, which is passed in my favor, they filed a suit stating that they are
They have filed suit against you.
against me, claiming that they are the right title interest holder. That suit is still pending, Your Lordship. Otherwise also they are not prejudiced, because that suit will take its own course. If they can prove their right title interest in that suit as well, they have already claimed confirmation of possession in their favor, Your Lordship.
Lordship.
But execution proceeding
Yes,
is
Lordship,
there.
execution proceeding, my confirmation
So,
will be taken over and it will be given to them, Lordship.
Lordship, but they can claim it through that suit as well. That is a separate issue. The only thing, when they filed this third party objection, the same document, Your Lordship, the 1968 sale deed, Your Lordship, that they have, that the other party has alleged in this issue number 3, was also made a contention in this third party petition, Your Lordship, under section 47. And that document, the most vital document, they have not placed it before the court. That
Whether any opportunity was granted to them.
Lordship,
Yes,
no
Your-
issue was formulated. In fact, Lordship, it is the duty of the executing court to frame issue, thereafter to adduce evidence. Third party rights to be decided by only by the executing court, Lordship. This, Lordship, I have
it
already
proceeds as a suit, Your
cited.
Lordship.
Then the records of this executing case would be required.
Lordship, in Babular decision, Lordship, the Supreme Court's 3-judge bench decision was
No,
discussed.
to
However,
appreciate everything, records of executing
Yes,
case,
Lordship,
it
whether
has been
chances- if chances given, I have not,
no case.
then I have no case, Lordship, I admit, Lordship.
There is another aspect of the matter, Your Lordship. This order 21 petitions, Your Lordship, they proceed as a suit. As
Yes.
submitted by my learned friend. So when a party files an objection, it, to some extent, it is like a plaint itself, Your Lordship. And all the documents that the party wants to rely upon in filing that objection has to be filed with the petition itself. For 2 years, this petition was pending, your lordship. From
No
20,
issue was framed, no,
And-
or evidence
and
was called
it is
from
before
the
this
party
honorable court.
lordship.
Now,
Under
why the
227.
order? Section 47 petition,
My learned friend has already admitted it's a plaint lordship. While deciding a suit lordship, opportunity to be given to the plaintiff to adduce evidence.
but you have to
Normally, we have adduced the documents along with PW1 lordship and DW1. My
It has to
learned friend is
It has to
also
be
aware.
filed with the plaint itself. your
it has to be filed with the
Lordship,
plaintiff.
normally, lordship, I have seen all the evidences,
No.
lordship, the originals were
What is the
submitted,
law?
along with the PW1 lordship.
We will call for the,
This document is for the first time placed under this 227 proceeding, your lordship, before this honorable. Nowhere before the previous trial.
When
or
I
before-
inquired whether any such registered sale deed is there, they stated that yes, it is there, it is mentioned in the objection petition, lordship, in the 47 petition. There is a mention of the registered sale deed. Court ought to have asked the petitioners to adduce the,
okay, heard Miss R. Chaudhary, learned counsel for the petitioners. Also heard Mr.
BJ Mukherjee.
PJ,
BJ Mukherjee.
BJ Mukherjee, learned counsel appearing for all the respondents,
So exponent number 1 to
up to
21,
21,
the
lordship.
degree holders.
1 to 21. None has appeared for respondent number 22 to 26.
Already service complete, lordship.
Yes. After hearing learned counsel for both sides, it appears that the records of title execution case number 10/2021, which no records of, where is the impugned order?
Lordship, page 84, annexure 9. Title execution 10/2021, present before the Civil Judge Junior Division, North Salmara, Abhayapur.
The records of Miss case number 22/2022, arising out of title execution 10/2021, would be necessary for consideration of the instant revision petition. Hence, let the stop. It also appears that said Miss case has already been disposed of by the impugned order by the said executing court. Let the records of Miss J case number 22/2022, arising out of title execution case number 10/2021 be called for from the Court of Learned Civil Judge Junior Division, North Salmara, Abhayapuri. It is made clear that the records of title execution 10/2021 need not to be sent, and only the records of Miss J case number 22 of 2022 should be requisitioned. Registry to take steps for requisitioning the aforesaid record. Let this case be listed again on. When is the next date fixed in the execution case? From where it will come? Abhayapuri,
Abhayapuri, lordship,
7th of November.
10/11.
7th of November. Considering the facts and circumstances of this case, till that date, that is 7th of November 2024, further proceedings of title execution case number 10/2021 shall remain stayed. List accordingly.
Order item 6.
Mid-page, your lordship. In this case, lordship, appeal was already admitted. And notice, we have taken the step as per office note dated 8/10/2025, no service report has been received in respect of respondent number 1 to 4 till date. A letter has been received from the Civil Judge Junior Division number 1, Hazrat Branch, Dhubri, dated so and so in this regard, and the same may be perused by flag L in IA and in RSS, same order, Lordship. In this case, what happened, Lordship, I have filed one suit for specific performance of contract, Lordship. My suit was decreed and thereafter learned First Appellate Court reversed the order, modified the order, saying that specific performance of contract cannot be granted in favor of the plaintiffs, but Lordship, the earnest money is directed to be paid to the plaintiff, Lordship. Against that, I have filed this regular first.
You are the plaintiff.
I am the plaintiff, Lordship.
Okay.
And thereafter appeal was admitted, but Lordship, I have filed one IA 1874 praying to stay of the judgment, as because if in the meantime,
1874. So.
in 1874 notice
No,
was issued.
stay of judgment under what provision?
As because Lordship, they will submit the earnest money before the court and we will be directed to take the money, Lordship. So as appeal was already admitted, stay of the judgment will be required, otherwise, Lordship,
Stay of judgment or stay of execution of the,
they have not yet filed any execution, maybe. I have no instruction about execution, Lordship.
Order 41 Rule 5 provides for stay of judgment.
Judgment, Lordship. Because the learned First Appellate Court in its order clearly directed that page 85 of my appeal memo, in view of the above, the learned trial court has committed an illegality in decreeing the suit for specific performance. In my opinions, in the facts of the present case, therefore the plaintiffs will only be entitled to return of the amount of rupees 2,50,000 paid as advance money along with interest at the rate of 8% per annum from 18/10/2010. That is the date of agreement to sell. So plaintiff's case is that they want to purchase the land. The money should not be returned to them. Order 41 Rule 5 says stay of the judgment.
No, where it is mentioned, stay of the judgment.
Order
Stay of the
41
proceeding,
Rule 5.
stay of the proceeding arising out of, it refers to only execution proceeding.
An appeal shall not operate as a stay of proceedings under a decree or order appeal from, except so far as the appellate court may order, nor shall execution of a decree be stayed. Of a decree, Lordship. So decree can be stayed.
Execution of a decree. Decree
Yes.
cannot be stayed. It is on order 41, Rule 5, to my understanding, is pertaining only to the stay of execution of a decree.
While appeal was admitted, normally the further operation of the judgment and decree has been.
Under what provision?
Order 41 Rule.
No, there is no. There has to be some provision. Only execution can be stayed under order 41 Rule 5. That is my understanding.
Lordship
you-
can record that the execution of the impugned.
But you have stated no execution case has been filed.
that they
We
have
will
received.
issue notice. If you,
Lordship may take it after some time. I will take instruction whether any notice was received. But
okay,
in my stay petition. I have
because
not-
what can be stayed must have to be in existence. Suppose execution case is not yet filed, it cannot be stayed. Only after,
Before execution, Lordship, we draft it as the order staying the operation of the impugned judgment and decree.
but there is no provision for that in the CPC.
Then I will
No,
take instruction,
no,
but
you
it-
show me the provision, I will grant you relief.
Execution of the operation of the decree and judgment.
Execution may be stayed. But for that, execution has to be in existence.
Then I'll
You take
instruction.
instruction.
Lordship, after some-
In 7.
Please, Your Lordship. Interlocutor application 942, Lordship. I am being the phone number 1, 2, and 2. The claimants have filed this interlocutor application for paying for a direction that the appeal is admitted and the stay was granted, but no direction was granted for depositing of the 50% of the awarded amount. I'm praying for that direction also.
Stay was granted ex parte
Yes,
or after your appearance.
for it.
Before appearance. Taken steps after.
Yes, Mr. Goswami.
This application filed on very strong ground on the sense that the other member had very correctly come to a finding, Lordship. I'll just take your Lordship. It's a very peculiar case. Lordship. While opposed that stay, Lordship, page number 7 of the judgment, interrogator, page number 19.
No, this miscase, this IA has been filed for directing the appellant to
Deposit certain
deposit
amount and withdraw.
50% above.
My whole.
You have not prayed for vacating this stay.
No, Lordship. Only my prayer is to direction to the insurance company appellant to deposit 50% of the awarded amount, and then the claimants may be allowed to.
Suppose if they don't deposit, then there has to be some prayer from your side. You have prayed for directing them to deposit.
That is modified.
They don't deposit, say, in spite of directions. Then stay has to be vacated. So
Yes,
that
there is a prayer to modify an order that is there in my prayer, Lordship.
yes. Yes, Mr. Goswami.
Lordship, I'm let's say in fact filed this appeal on the ground that there is a fraudulent implantation of the vehicle. The learned member Lordship had come to the conclusion that there has been false evidence and has given a direction, very strong indictment of the. It was found that PWT.
Where are you reading?
So
Okay.
this case, service on only respondent of 5 is yet to be completed. Otherwise, it can be hard, Lordship, to get instead of going for a year. Immediately, I don't mind if it is hard next month after service. Service may be awaited for 2 weeks, Lordship. It taken the steps on 29 on respondent of 5, and he's an important driver. Can't proceed without him. After service is complete, maybe
No,
straight
but-
taken up for hearing, Lordship.
But claimant, suppose ultimately if your appeal is dismissed,
It's not possible.
not possible,
It's quite possible. I'm saying it's
quite possible. So then why
only my
to,
point of view, Lordship.
then why to debar the claimant from the benefit? You pay 50%.
Because if it is turns out to be a fraudulent, then.
No, that is your contention.
My fault. Then
But-
how do I recover? Then it has been subject to some deposit of
No,
indemnity.
I just bond and submittable because they are suffering, and to maintain their livelihood, they're facing hardship because the claimants are the.
Then suppose ultimately the appeal is allowed. How will you how will they recover? What was the awarded amount?
53,18,872.
It is a big amount.
Some small amount, maybe Lordship, what, I'll just take 1 second, Lordship. The solicitor of this tribunal is as such directed to put up the file after delivery of the judgment for initiation of appropriate proceedings against the PW2 as well as the claimant number 1. Yeah. Evidence was found to be false. It's a clash between a wagoner and a heavy truck.
Putul, MSc case.
Some very incompatible evidence was there. A wagoner doesn't get any serious damage, but the truck appears to totally smashed up, Lordship. Heavy truck, 12,990 kg. and Wagoner is only 888 kg. When it is a collision,
No, what the tribunal held that
tribunal lordship in page 7 of the judgment lordship. I'll just read out the page lordship. I'm also a very quick disposal of this case because if my appeal fails, he should get the compensation. So maybe immediately within 2 months after. We can go.
page 7,
7, internal page 7, lordship. Page 19 of the judgment.
yes.
It starts from in fact report. I'll read from page 6, lordship.
Yes, please read.
I'll add, I'll add from the middle, lordship. Good day, it will be a long. The same was to establish the same, the claimants have relied upon the evidence of an eyewitness who has been examined as PW2. Before adverting to the evidence of the PW2, it is pertinent to mention that the claimant did not bring on record the reports of the inspection of the vehicle by MBI in spite of specific direction from this tribunal. The same were subsequently gathered from the learned trial court and on being produced by the insurer, the OP number 1. The report of the vehicle is significant as it gives an indication about the point of impact of the vehicle with another vehicle or object, including a human being, on the road. Admittedly, colliding vehicles in the present case were approaching each other from the opposite direction and the deceased victim was behind the wheels in one of the vehicles, the Wagoner. The PW2 one Joel Muzumdar in his evidence stated that a truck had come to the wrong side of the national highway and knocked the Wagoner on the front right-hand side. The MBI report of the Wagoner driven by the deceased victim suggests that it had sustained damage on its left-hand side. There is as such inconsistency between the eyewitness I was saying and the report of MBI. The eyewitness PW2 adduced by the claimants is not only appeared to be mechanical, it raised some doubts about its trustworthiness in the mind of this tribunal. To verify the integrity of the witness PW2, a random inspection of the available case record of this tribunal was undertaken. It was found that PW2 has adduced evidence as an eyewitness in another MSC case registered in this tribunal as MSC case number so and so. A scanned copy of such evidence is as such taken on record. The eyewitness, which namely Joel Muzumdar, is clearly a hired witness meant for helping the claimant to succeed. In this case, by adducing false evidence and as such cannot be considered to be a trustworthy witness. Evidence adduced by PW2 as such is rejected entirely. It seems that an attempt has been made by the claimants and their witness intentionally to rely on a piece of evidence which was known to them as false from before. The claimants were liable to be prosecuted under section 193 and 209 of the IPC. However, such process cannot be initiated in the present proceeding and a separate procedure needs to be as has been held by the Honorable High Court in so and so. Therefore, the next direction was the registrar of this tribunal as such is directed to put up the file after delivery of this judgment for initiation of appropriate proceeding against the PW2, Joel Muzumdar, as well as the claimant. Number 1. So, Lordship, the learned tribunal came to a finding of contributory negligence. 50-50. But my point is that our evidence suggests that our vehicle may not have been involved at all. Lordship may be allowed to Lordship picture as visualize this. A Wagoner comes in contact with a truck. I've given a weight also. The truck weight 12,990 kg. The Wagoner's weight is around 888 kg. Lordship, what has happened is the Wagoner is only mildly damaged, Lordship, as per MBA report. But a truck, even the cabin was smashed up, Lordship. Radiator, bonnet, etc. And the cabin, how can a cabin, a small vehicle, does not even reach up to that height?
So it just raises the possibility, suspicion that the vehicle may not have been involved in this. So Lordship, this whole needs to be looked at in entirety.
Where is the stay order? Separate miss case was filed. No.
It was annexed to the I also, Lordship.
In which I,
The present I that was also annexed.
Yes, in this eye.
no notice was issued to,
No. On a further Lordship before it. At the time of admission, the stay was granted. After that, only I took steps,
then you have to pay 50%,
50,000,
50%.
50%. Yes, yes, I'll pay with that, bank indemnity Lordship. That if at all, he has to reimburse that amount if the vehicle is not found to be involved. Huh? Bond, indemnity bond. I will give you the bond before it is.
What is your name? Heard
Burwa.
Mr. A. Burwa, London Counsel for the applicant slash claimant respondent. Also heard Mr. R. Goswami, London
The appellant, Chalaman.
Counsel for the appellant insurance company. You have taken steps for issuance of notice on other respondents.
Yes, sir. Service completed on all except 5 Lordship. That step I've taken again.
The present I has been listed for the first time, but there is a order was
Not-
checked.
not-
The order was checked, but that order might have been passed in the appeal Lordship.
Yes.
Because this is listed first time after I have filed it. Because
The order has been.
learned senior name is their heart,
Hmm.
R. Goswami.
Stop.
the appel.
Stop. Though by filing this interlocutory application, the applicant claimant has prayed for directing the insurance company to file, to deposit 50% of the awarded amount as a condition for stay of the operation, stay of the execution of the impugned judgment and award passed in MEC case number, case number
931 of 2018.
931 of 2018 by the Motor Accident Claims Tribunal,
Number 2, Kamrup.
number 2, Kamrup Metro. at Guwahati. Stop. Learned counsel for the petitioner has submitted that the in the connected MAC appeal 303/2022, which has been filed by the appellant insurance company, an interlocutory application bearing IN number 1602/22 was filed by the insurance company for stay of the operation of the impugned judgment and award, stay of the execution of the impugned judgment and award, and a coordinate bench of this court on the day of motion itself, without issuing notice to the present claimant, had granted the stay and disposed of the said appeal, the said interlocutory application. Learned counsel for the applicants has submitted that as the by the impugned judgment, the compensation has been awarded to the present applicant by present applicant Putul. When the impugned order was passed,
The award,
award,
dated 12/1/2022.
award by the impugned award on 12/1/2022. That is about 3 years ago. But the applicant / claimant are yet to enjoy the fruit of the award. And the fruit of the award stop. He submits that the stay granted by the coordinate bench of this court in IA number 1602/2022 may be remain operative only on filing of on deposit of the 50% of the awarded amount. On the other hand, Mr. R. Goswami, learned counsel for the insurance company, has vehemently opposed the prayer of the applicant for deposit of 50% of the awarded amount by the insurance company on the ground that in the impugned judgment itself, an observation has been made by the Motor Accident Claims Tribunal, concerned Motor Accident Claims Tribunal, that the claimant has adduced false evidence by producing a false witness, that is PW2, and accordingly a separate criminal proceeding was directed to be initiated against the claimant as well as claimant means how many claimants are there?
He claimants.
Claimants.
The action
Claimant
was
number
against
one to the
claimant.
Claimant number 1 and PW2. And therefore, he submits that instead of directing the insurance company to deposit the 50% of the awarded amount, an endeavor may be made to dispose of the appeal itself at the earliest. I have considered the submissions made by learned counsel for both sides and have gone through the records of this case. Stop. It appears that the order dated 22/5/2024 passed by a coordinate bench of this court in IA civil number 1602/2022 was made ex parte without hearing the present applicant. It also appears that though an adverse observation has been made against claimant number 1 and PW2 by the Motor Accident Claims Tribunal. However, ultimately, the claim petition was allowed and award was passed in favor of the claimants. Stop. It also appears that that more than 3 years have been passed since the date of passing of the impugned award. However, in this case, in the connected MSC case, the services on all the respondents are yet to complete. Considering the aforesaid facts, this court is of opinion that ends of justice would be served only if the stay granted by order dated 22/5/2024 is allowed to remain operative, subject to condition of payment of 50% of the awarded amount by the insurance company. Stop. Accordingly, the order dated 22/5/2024 passed in IA Civil number 1602/2022 is hereby modified to the extent that the stay granted therein shall remain operative only if the applicant, only if the insurance company, that is Messrs. Cholamandalam General Insurance Company Limited, deposits 50% of the awarded amount within how much time?
6 weeks.
Within 6 weeks from the date of this order. The prayer is according, this interlocutory application is,
On being deposited, the,
no, suppose they don't deposit,
if after deposition,
no. After deposit, if they don't deposit, the stay will be vacated and you file an execution proceeding before the. क्या लिखा? Last line. Accordingly disposed of. Disposed of. In MSC case, heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. What is your name?
A Borua.
A. Borua.
Respondent number 1, 2, and 3.
Respondent number 1, 2, and 3. On perusal of the office note dated 1/4/2025, it appears that AD cards in respect of respondent number 5 and 6 have not yet been returned back. Neither the affidavit in respect of the service of notice through Dusty mode have been filed. You take fresh steps, Mr. Goswami.
It was sent on 29 only, 20th September. So maybe a service may await it for under 2 weeks.
Okay. Stop. Await further for the service report. List accordingly.
6 lordship is already complete, only 5 is.
6, how?
I लिखा है sir,
In the I dated 13/8/2025.
942 of 25 I to लिखा है sir.
The office note is the I.
ID card in respect of 6 Katidio. In respect of respondent R5 has await further. Leave this matter after 6 weeks.
Much of it.
Lordship, item number 8 and 9, Lordship. Lordship, may kindly adjourn the matter for the day, Lordship.
But the respondent, Lordship. We have
I
no
pend it for
response.
the respondent, Lordship.
Heard Miss
F. Ahmed.
F. Amir,
Ahmed.
F. Ahmed,
AH APD.
learned counsel for
Appellant.
appellant. 8 and 9
8 and 9, Lordship. Both the matter.
also heard Mr.
D. Kolita, Lordship, on
D.
behalf of Mr. G.P. Bhumik.
D. Kolita, learned counsel for the respondent. A prayer has been made at bar for adjournment. Why you are praying for adjournment?
Lordship, my senior, he is engaged in some
A
other.
prayer has been made by learned counsel for the appellant for adjournment on the ground of personal difficulty of the conducting counsel. The respondent has not, learned counsel for respondent has not opposed to the prayer. Hence the prayer is allowed and the matter is adjourned for the day.
Obliged.
Yes.
In fact, I have a part heart matter in court 9, Lordship.
Yes.
So in item 6, I have obtained the notice they have already received. And by order dated 6/9/25, I have downloaded. Learned counsel for the judgment debtor has filed petition number so and so praying for another date to submit their written objection. On the ground that they have preferred an appeal, that is IA Civil 1874, 2025 RSI 91, 2025 before the Honorable Guwahati High Court. So it was already informed before the executing court. So your Lordship may.
Execution case has been filed.
Yes, Lordship. Title execution number 3 of.
This item number
6, Lordship. I have served one copy. Lordship.
which IA you are submitting?
1874, Lordship.
What is 1875?
1875, Lordship, I have prayed injunction so that they, during the pendency of the appeal, they should not transfer the lead, Lordship.
And 1874 execution is 10.
Yes, Lordship.
1874 we will stay
Yes, Lordship.
and 1875 will
Lordship,
be
stay injunction, Lordship, not to alienate the property to any third party so that in during.
no,
the
1875 we will issue notice.
Lordship. And it is within their knowledge as because in the meantime, my judgment debtor already filed a petition before the executing. court.
No, execution we will stay
Lordship,
and this we will issue notice.
Lordship,
Item number 6, Peter.
Lordship, I have submitted the copy order. Obliged.
Item number 1.
Yes.
May it please your Lordship. This is the second bail application. The earlier anticipatory bail application was already rejected by your Lordship. It relates to Sonapur PS case number 113 of 2025, wherein allegations of human trafficking and gambling and betting has been arrayed against the accused persons. Now, this petitioner before your Lordship is the owner of that club. He was not there at the time when the occurrence of the incident. However, I'm not on merits, your Lordship. The only thing I'm praying before your Lordship is that his mother expired on 12/10/2000.
You are a free person. What relief you are seeking? You are a free person now. You can attend your funeral.
No, your Lordship. I leave it to your Lordship at the end of the day. But what I'm praying for your Lordship is that there are some rituals in the customs that has to be done by the son. And therefore his father is also an aged person. Mother was 82.
Police could not arrest you so long.
Other accused have also been released on bail, your Lordship, as of now. And the other owner of the Nirvana Club, my wife, she has already been released on bail, anticipatory bail by this honorable court.
Yes, because materials were
Who
not
are
there
not there. The
against her.
only thing,
But against you, I remember the case, there are
there has been
materials.
some statements, your Lordship. Now, those statements has already been made by all the witnesses. Now, there is no issue, there is no question of tampering with the evidence at this stage or threatening of any witnesses.
No, but
Assuming-
for second bail, what is the ground?
The only ground I am.
When your mother expired?
On 12/10/2000, the petitioner's mother expired, 12/10.
So you did not participate in funeral?
No, your lordship.
Why?
I could not come, your lordship, for natural reasons that I am still running away from being arrested, your lordship. That I must admit it honestly. Everything is there on record, your lordship. I'm not here to say something. which is
If
not
you have not attended the funeral, what other ritual you want to attend now?
Your lordship,
You have attended the most important ritual. You have failed to attend the most important ritual. Now,
Thereafter-
what ritual you want to attend?
thereafter the Sraddha ceremony and all those things are there, your lordship, which we have to do. As per the Hindi rituals, customs and all. And your lordship will see one thing that the charge sheet has been submitted, all the testimonials, the evidence of the victims have
No,
been
that will
recorded.
not help you.
And your lordship will protect me till then, your lordship. Thereafter, your lordship will peruse the case diary and your lordship will take a call on that. I am only seeking for this purpose, nothing more, your lordship. Which I have honestly stated in my bail application, your lordship.
Yes, Mr. Sharma.
Yes, lordship has gone through the case diary and earlier rejected the prayer, lordship. And other thing lordship has already submitted. Only thing is that only the question of the funeral that's.
When is your ritual?
I-
When is the ritual?
Today is the third day, your lordship.
No, which ritual you want to attend?
Your lordship, the Sraddha ceremony it will take 13 days. And thereafter, so till then, your lordship will call for the
No.
case diary and protect.
Not till then. You are still following some rituals
Yes, your lordship.
wherever you are.
Not exactly, not comfortable, your lordship. This is the family, I have to participate in the family prayers and everything, your lordship. I would not have said, the only issue is that his mother has expired. Had it been any other person's, I would have not seek bail on that ground, your
No,
lordship.
no, I am wondering why you missed your funeral of your mother, only fearing arrest.
Otherwise, if your lordship permits me, I'll just place one judgment with your lordship's kind permission.
Is it in case of anticipatory bail?
Yes, your lordship has gone through it. I don't know how far your lordship may agree with it. The only thing was that I was not caught red-handed out there at that place. So this judgment says when the other accused has been granted the bail, so similar accused should also be the granted the bail. May I
No.
read this para?
No, 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 I don't agree.
That's up to your
Because I remember the incriminating ingredient against you.
Exactly.
Two of the victims have specifically,
Your lordship, those are the statements, those are yet to see the light of the day. What I'm trying to say is that there is no question of evading any arrest, tampering with the evidence or threatening any witnesses.
no, you are a evading person. Police
I,
has,
your lordship will take my words for granted. Your lordship knows it very
whether
well.
charge sheet investigation is still going on.
So your lordship, in the charge sheet, I have categorically stated in the.
Charge sheeted case,
Yes, your lordship, it is.
charge sheeted case.
Yes,
Then
your lordship, but in the charge sheet, it has been said that I am an absconder.
you have received summons.
I was not.
Then
there.
you don't have a case. If charge sheet has already been filed, then where is
No.
your case?
No,
You will
it is-
receive summons from the trial court.
In the charge sheet, they have stated that I am still an absconder.
But
your
you
lordship.
have, no, mayor's statement is not enough.
No,
to-
I am not saying that. The charge sheet is saying. so.
Mayor's statement in the charge sheet is, you know the law. At the first instance, court will issue summons, even if you are an absconding accused. So there is no apprehension of your getting arrested now.
Lordship will protect me till the rituals are complete.
No, you don't require protection. There is no,
No, your lordship will take it in, take my words. I need your lordship. Only to attend this, let me complete
no,
this.
what are you fearing of?
No, I'm not, definitely when I come to my home for all these rituals, I'll be arrested.
By whom?
The police authority.
Why? Without warrant, how they can arrest in a charge sheeted case? Police cannot arrest now after filing charge sheet.
No, in the charge
Ah.
sheet, it has been stated that I'm. an
Maybe,
absconder.
maybe, But unless a warrant is issued against you after filing a charge sheet, you cannot be arrested.
Your lordship
Court
knows,
has to issue warrant.
your lordship knows how the things functions.
No, no,
Even then, your lordship will protect me till then, your lordship. I'll
no.
cooperate with the investigation, whatever.
Lord
is-
Mr. R. Singha, learned counsel for the petitioner. Charge sheet has protected you from arrest. Now you have sufficient time. You have not yet received summons from the trial court. So there is nothing to apprehend arrest.
Your lordship, things might go the other way also, therefore I'm before your lordship.
No.
Your lordship only protect me till then.
Protect
Thereafter,
from whom?
from being arrested, your lordship. Let me perform.
How you
rituals.
can be arrested? Unless there is a warrant issued by the court.
The warrant may be issued tomorrow.
Court will not issue warrant at the first instance. It will issue summons. If it issues warrant, you can challenge that order.
No.
The law is settled law.
I understand your lordship, but for your lordship will protect me till then, your lordship,
That
on
I
the-
want to understand. Protect from what?
from being arrested, therefore I'm before your.
Why
lordship.
you will be arrested
Your lordship.
when there is no pending NBWA? Heard Mr. R. Sinha.
Your
Learned
lordship knows how the police functions, your lordship.
Therefore, I am asking the question. Police will not arrest you without a warrant. This application under section 482 of BNSS has been filed by the petitioner, namely Shri Pawan Kumar Sharma, who is apprehending his arrest in connection with, what is the PRC case number? In connection with Sonapur PS case number 11,
Session case number 179, your lordship,
in connection with Sessions case number 179
of 2025.
of 2025. Corresponding to Sonapur PS case number 113/2025 under section 143/317 within bracket 4/49/3 within bracket 5.
If your lordship
Of
kindly come
BNS.
to page 54, I'll just draw your lordship's kind attention to one of the statement in the charge sheet.
BNS. Page 54.
Yes, your lordship.
Yes.
As the lordship got it, the third para, hence. As the allegations are found to be established by sufficient evidence and witness testimony, the charge sheet is hereby submitted before the honorable court against the above named accused persons for trial under the aforesaid section. As for the absconding accused Pawan Sharma, alias Pawan Sharma, son of such and such, efforts are being made to apprehend him and a supplementary charge sheet will be submitted against him after his arrest.
So charge sheet has not been filed against you.
In his case, your lordship. The lordship will protect me till then, your lordship. After thereafter, lordship takes a call. I'll not say anything on that. I'll not make any submission on merits on that case.
Calicut. Under section 143, 317, 49, 35 of BNS. Read with section 14/15/16/17 of Assam Games and Betting Act. Learned counsel for the petitioner has submitted that prior to filing the instant anticipatory bail application,
That is at page 26, your lordship.
the petitioner had approached this court earlier by filing an anticipatory bail application
1786 of 25.
bearing number 1786/2025. It was rejected by this court after perusal of the case diary as sufficient materials were found against the present petitioner in the case diary. Learned counsel for the petitioner has submitted that though against all the co-accused, charge sheet has been laid. However, the petitioner has not been named in the charge sheet and further investigation is going on in respect of the present petitioner. Stop. He further submitted that this, Mr. Sharma, this is a blunder by the investigating officer. When materials were there before in the case diary, what prevented it from filing charge sheet showing him an absconder? What is the last line? Further submitted that it is stated in the charge sheet that as the petitioner has not yet been apprehended, therefore a supplementary charge sheet would be filed after apprehension after arrest of the petitioner. Learned counsel for the petitioner has submitted that due to the aforesaid endorsement in the charge sheet, the petitioner is apprehending that he may be arrested at any moment. He further submits that in the meanwhile, on which date your mother expired?
12/10.
On 12/10/2025, the mother of the petitioner, what material you have produced for showing you?
Your lordship, there is a record in the cremation ground. As I could not obtain the death certificate, the cremation grounds records are there at page 67, your lordship. The type copy is at page 67 and the original copy is at page 68.
Kalika is mother of the petitioner, namely late Geeta Devi Sharma,
Aged 82 years.
had expired and the petitioner has to attend the rituals to be followed after the death of her mother, his mother. Stop. Learned counsel for the petitioner has further submitted that the Shraddha ceremony of the mother of the petitioner would be held on till what time?
Another 13 days at best. at
No, when
max.
is this? You have to surrender back. When is this?
Your lordship will, generally it is done within 13 days. So today is the third day. So another 10 days, your lordship.
Till you should know when you are performing Shraddha of your mother.
12 plus 13 till 25, your lordship will protect me. Till 25th, your lordship.
Will be held within 13 days of her death, and therefore he being son of the deceased, he need to attend the religious rituals post death of her mother, his mother, and therefore he seeks protection from arrest for at least next 15 days. Stop. Since it appears that further investigation is going on in respect of the present petitioner, the perusal of the charge sheet, case diary would be necessary. The learned additional public prosecutor is requested to produce the case diary on produce the case diary on, when is the 15 day, 15th would be
It's 29.
on 29th. On 30th October. Stop. To enable protection of the, to enable the present petitioner to attend the religious rituals of his deceased mother. Interim protection from arrest is granted to the petitioner till next 30th of October. The petitioner shall appear before this court or before the IO, before the investigating officer on 30th.
Or before that also, we can appear your lordship.
On 30th. If in the meanwhile if in the meanwhile he is arrested in connection with the aforesaid case, he shall be granted interim bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of the arresting authority. Let this case be listed again on 30th of October with following conditions. You have to surrender. Third condition, he shall appear before the investigating officer of this case on 30th of October. 30th of October, you have to appear. If before that you are arrested, you will be granted bail.
I'm deeply obliged. Your lordship.
Item 27 from subject.
If your lordship directs, I can appear before that also.
If police is unable to arrest you till day, let us see whether they can.
Yes, your lordship. I'm deeply obliged.
Item number.
Lordship, kindly peruse the office note dated 10/10/25, my lord.
Yes. Yes.
My lord, service of notice, complete my lord, upon respond number 1 to 7 and 10, my lord. And service on respond number 11 awaited, my lord. And service is not complete upon respond number 8 and 12, my lord. We have again take fresh steps on respond number 8 and 12, my lord.
You have to take steps. You will
Again,
take fresh steps.
Again take to fresh steps, my lord.
Heard Miss N. Sharma, learned counsel for the petitioner, learned counsel for the appellant. Also heard Mr. L.R. Majumdar. You are appearing for?
1 to 7.
Appearing for respondent number 1 to 7. On perusal of the office note dated 10/10/2025, it appears that respondent number 10 has also been duly represented by the council by filing wakalatnama, whereas notice issued to respondent number
8 and
8 and 12 have been received back with an endorsement within inverted comma left and addressee cannot be located. It also appears that notice issued to respondent number 11 has not yet been received back. Stop. In view of above, the appellant is directed to take fresh steps for issuance of notice upon respondent number 8, 12 and 11 by registered post with ID as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Lordship, there is a IA that. 1, 2,
My lord,
9, 7.
this I am for stay, my
It is
lord.
for.
My lord, there is connected appeal, my lord, which already, my lord, there is stay, my full stay, my lord, on that, my.
In this case, there is
Connected appeal, my lord, same accident and same person, claimant.
in that connected appeal stay has already been granted.
Yes, full stay. my
Therefore, you are not praying for stay in this case.
lord.
You,
They have not appeared before, my lord, that's why.
they are not pressing for IA.
Lordship, but they have filed a petition that is
Where is the IA?
1297/2024.
You are not pressing for the IA.
My lord, no, my lord,
You are not pressing.
yes, ma'am.
They are
In
not.
connected case, Lordship.
My
no-
lord, actually, my lord, they have no valid insurance policy. And they second, my lord, they have, there is.
This IA has
valid-
been filed by insurance company.
Yes, my lord.
They are not
But
pressing.
50% is be paid, Lordship. That's
No,
not
but
what-
they are not pressing for IA. Then why they will pay 50%? You can go for execution.
Lordship, we can also file appropriate interlocutory application
For-
for a direction for making payment of 50%.
No, when they are not praying for any stay, then why they will pay 50%? They have obtained stay in a different case.
Yes, but in that case, we are not party.
So
How
you
we
are,
affected by that?
so you are free
Same
to,
party, my lord.
you are free to move execution application before the. Heard Ms. L. Sharma, learned counsel for the applicant, also heard Mr. L.R. Majumdar, learned counsel appearing for respondent number
1 to 7.
1 to 7. Learned counsel for the applicant has submitted that as the execution of the impugned judgment and award has been stayed in a connected MSC appeal number
Number 246, MSC appeal number 246 of
246
2024, my lord.
/ 2024. Hence, the applicant is not pressing the instant interlocutory application. So considering the submissions made by learned counsel for the applicant, this interlocutory application is disposed of on not being pressed.
Next, my lord.
Meant to which order? In IA disposed.
In this matter, let's see, we have tried to, already the terms and conditions of settlement we have arrived, let's see. And it'll be after 2 months. In the meantime, we will complete all the process.
Item number 10.
Yes.
Heard Mr. U. Datta, learned counsel for the
Appellant.
appellant. Also heard Mr. A. Khonikar, learned counsel for respondent number 2, as well as Mr. N. M. Datta, appearing for respondent number 1. It is submitted at bar that an amicable settlement has been reached between the parties and some time may be granted, some time is prayed for finally arriving at the amicable settlement. Stop. The prayer is allowed. Let this matter be listed after 2 months.
Like, Diploma. Hello. May I please your lordship?
Yes.
What is different second appeal against the reversal of the decree,
By the first appellate court.
first appellate court? The trial court dismissed this suit and after appellate court reversed the decree, dismissed, allowed the appeal. So therefore, against that, then lordship, his second appeal has been deferred. Once single law point. One single law point.
One
Lordship,
single?
law point. Question of law,
Question of law.
substantial
Yes.
question of law has been
What is?
formulated by
What
the
is?
order dated 21/5/2014.
21/5.
21/5/2014.
Barred under section 4(1) of Benami transaction.
Lordship. But the appellants, lordship, subsequently it has been stated that the appellants are at liberty to frame any other substantial question of law at the time of hearing.
In the memo of appeal, what?
The
you
memo of appeal, lordship, there's two substantial questions of law has been proposed. At page 12 of the memo of appeal. Lordship got it. Page 12 of the memo of appeal.
Yes.
Okay. The proposed, at that time, the proposed question of law is one, which has been formulated by the Honorable Court. Whether the prohibition provided under section 4(1) of the Benami Transaction Prohibition Act 1988 is applicable in institution of the title suit number so and so by the respondent plaintiffs as the civil property was admittedly purchased by way of Benami transaction by their father in the year 1953 by the Exhibit 5. The second proposed substantial question of law is that whether the evidence lays beyond the pleadings are admissible and acceptable as per section 5 of the Indian Evidence Act to declare a suit or proceeding.
The first question,
Lordship, this first question has been formulated by the Honorable Court. As a substantial question of law.
it was not decided by the first appellate court.
Lordship,
Whether during the first appeal,
Lordship,
this question was raised or not.
that has been decided.
That has been decided.
The first question regarding Benami transaction.
What was decided?
That's been decided that as
Against you, that
against
it,
me, we have taken the plea. Because there's an admission, Your Lordship, that the property was purchased by way of Benami transaction. But the appellate court says, by taking a reference of the Honorable Apex Court of the 2007,
No, now whether this remains a substantial question of law.
that has been formulated again.
No,
before this Honorable Court.
that is my query.
Yes.
Whether,
as on
without
date-
going into facts,
Yes. Without going to fact.
whether this question can be decided.
Now, Lordship, that has been 2007 decision. I'm going to read out that provision, Sir Lordship, that the judgment findings arrived by the appellate court.
No. Before coming into facts,
I'm not on the facts.
my,
The question of law.
you listen to my query. The query is whether the suit of the plaintiff is barred under section so and so of Benami Transaction Prohibition Act. Your submission is that this question was raised before the trial court,
Trial court.
as well as the, before the.
Trial court held it. That this is Benami transaction is there. It is a, so suit is not maintainable.
And it is again raised before the appellate court,
We have not appealed, but that the appeal was preferred by the plaintiff.
but
And
it was decided against
decided.
you.
It was
Now,
decided.
my query is for deciding this question, whether we have to go into question of facts.
Lordship, what happened subsequently? What happened, that question of law has been decided affirmed by the Honorable Apex Court. Holding that as the property was purchased prior to the act come into force. So that is why that retrospective effect cannot be given effect to. So that is why that question gone.
So,
So that not remain in force. That so far this substantial question of law is concerned. Because in the last, that is why Lordship, in the year 2007, earlier it was decided in
no, what was the case of the plaintiff before the trial court?
before the trial. No, that is why I am going to read out the claim.
No, don't read out. Tell me the story.
Good.
What gist?
Plaintiff case is that the predecessor of the plaintiff, Harendra, predecessor of the plaintiff, Harendra Prasad, Harendra Nath Chaudhary, he purchased the land in the year 19.
How much land is there?
Approximately.
Approximately. So, I will not go into question of facts,
So I'm not going.
but you
Area
have
of
to
the
tell
land.
me the gist of your case.
Definitely. Schedule 1. Schedule 1 is about is a
40 cubic by
40 cubic length. And schedule 2, 24 cubic, along with an RCC building.
Okay.
That land was, according to the plaintiff, their predecessor, Harendra Nath Chaudhary, purchased the land from one Nagendra Chaudhary, Nagendra Nath Das.
Yes.
In the name of his father, Basanta Nath Chaudhary. By way of a Benami transaction, it is an admitted case. It is their case.
Yes.
Now, so that Nagendra Nath Chaudhary, Nagendra Nath Das, sold the land to Basanta Nath Chaudhary, on condition that he will repurchase the land again.
by repaying the amount. Already he had received from the Basantanath Sobri. But subsequently, as he could not purchase the land, he executed a deed of relinquishment, that is Exhibit 1, in favor of Harendranath Chaudhary, not in favor of Basantanath Chaudhary. Rather, it has been executed in favor of Harendranath Chaudhary.
Okay.
So, on the basis of that relinquishment deed, the present plaintiffs have claimed the right title and interest in respect of the scheduled property, claiming that this property belongs to their father, Harendranath Chaudhary. Because the earlier sale deed executed by Nagendranath Das in favor of Basantranath Chaudhary was a Benami transaction of Harendranath Chaudhary. So that is why relinquishment deed was executed. That is Exhibit 1 in favor of Harendranath Chaudhary by Nagendranath Das. So that is why Harendranath Chaudhary became the absolute owner of this scheduled property. It is their claim. So after getting the sale deed, after getting the relinquishment deed, so the property was let out to some office, and subsequently the present defendants as permissive occupier came into occupation of the scheduled property. So as when they refused to vacate on being asked, the suit has been filed for declaration of right title and interest and for recovery of possession.
And you are the descendant of Harendranath Chaudhary?
No.
Of,
We are the descendant of one Babai.
you are the defendant in the original
Yes,
suit?
yes. We are the descendants of one Baba Sena Singha.
Permissive occupier.
According to the plaintiff, we are the permissive occupier.
Okay.
It is their case. But when we file the written statement in the trial court, we have stated that the land originally belongs to the predecessor of Babai Sena Singha. So Babai, after the death of the father, Babai Sena Singha inherited the said land, that property, scheduled property. So thereafter, in the year, subsequently they filed a suit in the year 2005, when they have come to know.
What was the title suit number?
Title suit number 143/2005.
It was dismissed.
No.
It was decreed.
In our favor. That suit, that title suit, because when the plaintiff defendants had come to know that in respect of the scheduled land, Basantranath Chaudhary, thereafter Harendranath Chaudhary, they got their name mutated. So that is why challenging that mutation, the present defendant filed a title suit before the learned trial. That is title suit 143/2005, which was accordingly decreed expert.
What relief was sought for?
Declaration of right title and interest, confirmation of possession, and injunction.
Okay. That was decreed.
That was decreed. Against that, the state of Assam was also party. So none of them they have contested. So accordingly, the suit is decreed. So when they filed, when the present appellant, they were defendant in the present suit, filed the written statement, they have stated that we got the decree in a suit. That is the title suit number so and so, 143 of the 2005, and the present suit is to be dismissed. I am not on the entire facts. So having come to know about the pleadings made in the written statement, about the facts made in the written statement, the present respondents who are the plaintiffs, they filed an amended application, amendment application of the plaintiff. And by way of amendment, they want to incorporate a new prayer, that is to pass a decree challenging the decree passed in title suit number 143 of the 2005. That is that which was allowed, and that prayer was D, double D, small d. That the amended prayer incorporated after filing the written statement, that is for a declaration that the judgment and decree obtained in title suit number 143 of 2005 is a collusive, void, ab initio, fraudulent, and inoperative, and liable to be set aside. Only that prayer has been incorporated.
Yes, thereafter.
So, except the prayer, no other pleadings was made or amended or incorporated in the plaint. Why that is to be declared as a null and void? No pleading. So the learned trial court, after collecting the evidence and going to the record, it was held that as there is no pleadings, so the evidence tried to establish, the evidence adduced by which tried to establish that the decree passing is to be null and void, it was did not consider, rather it is rejected, because no pleadings was there. When the appeal was preferred,
yes,
before the appellate court, they laid an additional evidence under order 41 rule 27 by the plaintiff, and some documents have been exhibited in the appellate court, stating that the decree was obtained fraudulently, as because prior to the filing of this suit, that Nagendra Basanta Nag Chaudhary and Harendra Nath Chaudhary were died. So in the name of a dead person, suit was filed. So that is why they had no knowledge about
it. Okay, thereafter.
So thereafter the learned appellate court held on considering those evidence that considering those evidence held that the decree passed in title suit number 143 of 2005 is a collusive one. So that is why that was also allowed. So that point decided against the respondent, against the appellant, present appellant. Now that is why we have taken the plea before the honorable court. Is a substantial question, is a proposed, is a substantial question of law. Without there having any pleadings, if any evidence laid, that can be considered as an evidence. That is why whether there is a pleadings or not, for that purpose to know about it, the plaint is to be read out. Because plaint is totally silent. All right, they had no knowledge about it earlier at the time of institution of the present suit. That is title suit number 87.
No,
of
you
the 2007.
took this plea before the first appellate court,
Not,
that there is no pleading.
no pleading. That plea was taken in the trial court.
And,
trial court rightly decided in our favor,
and in first appellate court,
decided against myself.
but you took that plea.
Yes, no, appellate court they have filed. In a appeal, they have preferred.
During argument,
During argument, we have taken the
That-
plea. Court says, no. Court says, as the evidence has been laid, that was exhibited, and from the document it reveals that those persons died earlier. So that is why the court found that the decree passed in title suit number 143 of the 2005 is a null and void. Now my submission before the Honorable as well as the appellate court, whether there is any pleadings to the effect. And if there is no pleadings, whether the law permits to lay the evidence, if evidence laid, whether that can be considered. That is the subsequent question of law. Because the proposed subsequent question of law, because the Honorable Court, when framed this issue, because framed this law, subsequent question of law, it was held and then stated that the appellants are at liberty to frame any other subsequent question of law at all at the time of hearing.
Yeah.
There is another question of law is there, issue is there. Non-gender nature, but there is an admission. I'm coming to that. But so far the benefit transaction is concerned, I am not pressing it because law has been laid down.
suit is not barred.
It is not barred because property was purchased in the year 1953. And there is a decision of a Supreme Court on the basis of what the trial court had decided.
In which case it was settled?
Lordship.
So your submission is this substantial question is no longer remains a substantial
Lordship,
question.
because
And you are praying for framing of additional.
additional subsequent question of law.
Formulating additional substantial question.
Lordship.
And that is whether evidence beyond pleading are admissible. and
Lordship.
But that is a settled proposition.
Question of law,
It is not admissible.
not admissible.
So whether this court can go into that.
Lordship. Definitely. That is why the settled principle, although the evidence has been laid, but they are having no pleadings, that cannot be considered. So that is why we have to go to the plane, whether there is pleadings. Only prayer has been incorporated. Because in the written statement, it has been clearly stated how the decree was obtained. They have not said anything. Rather, incorporate only one prayer, that is prayer number DD at page, Lordship.
No, before that, why it is, let us answer the question which has been formulated. Why it is not barred under section 4(1)?
Lordship,
Where is the judgment?
judgment, your Lordship. In the citation of this Honorable Apex Court, in 1989 AIR SC, which was considered by the learned trial court. It was held,
Page number?
page number, Your Lordship, 1989 AIR SC 1247.
Party's name?
Party's name Mithilesh Kumar and another. Appellant versus Prem Bihari Khere, respondent. So I am reading out the relevant para number
No,
20.
not required. You are not pressing
Lordship.
your
Because why I am
counsel.
not pressing? Because at that time, it was not within my knowledge, Lordship, sorry to say. Because that judgment, by this judgment, Honorable Apex Court held that any suit filed admitting that the Benami transaction suit is not maintainable as per section 4. So later on, that judgment has been overruled by the another decision of the Honorable Apex Court, AIR 1996 SC 238. So party's name is not with me, Your Lordship. AIR 1996 SC 238. And later on, Your Lordship, that has been appealed. That has been 996, no? A party's name is R. Rajagopal Reddy versus Padmini Chandrasekhar. And the said finding of the Honorable Apex Court was relied in another decision which was considered by the learned appellate court in its judgment. It was the 2007 6 SCT 100.
Okay, now the law is it is not barred.
Lordship,
It is not barred.
it is not part because
Okay.
as the retrospective effect cannot be
So let us forget about that substantial question.
substantial question of law. Now the second question comes.
Now there remain no substantial question of law. Therefore, your appeal fails.
Appeal fails. So for the Lordship, the appellate are liberty to frame any other substantive question of law. Now the question is whether the evidence should is maintainable. Now my decree has been declared as null and void on the basis of a prayer made by the plaintiff in a suit. That is prayer number DD, double D. Without their having any pleadings. This is one aspect. And there's another aspect. From the judgment of the appellate court, it reveals because the claim of the plaintiff, respondent is based on Exhibit 1.
Yes.
Why? Because Exhibit 1 is a deed of relinquishment executed by Nagendranath Das, the original owner, from whom Basantanath Chaudhary purchased the land. So, sale deed was executed in favor of Basantanath Chaudhary by Nagendranath Das, but relinquishment deed was executed by the Nagendranath Das in favor of Harendranath Chaudhary, the son of Basantanath Chaudhary. So that is why they have taken the plea that as the land was purchased by Harendranath Chaudhary we have a Benami transaction. So subsequent relinquishment deed, that is Exhibit 1, executed by the Nagendranath Das, that he is not going to repurchase the land, that is a relinquishment. Right was there in the original treaty, executed in favor of Basanta Nag Chaudhary, that as and when I will get the money, I will repurchase the land. That right was in the original treaty, that is Exhibit 5. But when he could not purchase the land, instead of executing the relinquishment deed in favor of Basanta Nag Chaudhary, deed was executed in favor of Harendra Nag Chaudhary. So on the basis of that relinquishment deed, Exhibit 1, the present respondent plaintiff, they claim their title. Now, the learned appellate court disbelieved that document, because that cannot be considered as a title deed.
Yes.
If that cannot be considered as a title deed, to acquire title over the suit property by Harendranath Das or the present plaintiff, then land remains in the name of Basanta Nag Chaudhary, the father of Harendranath Chaudhary. Then, if the land remains in the name of Basanta Nag Chaudhary, there is an admission in the record, in the case, that Basanta Nag Chaudhary had 5 other sons. That was why that plea of non-gender necessary party was taken, issue was framed. But that issue was decided in favor of the plaintiff, even in favor of the respondents, by the trial court. But by the appellate court, that issue has been reversed. Not a necessary party, according to him. But he has disbelieved the Exhibit 1. If Exhibit 1 is disbelieved, on the strength of which the present respondent plaintiff are claiming title, being the legal heirs of Harendranath Chaudhary, then how the learned appellate court come to conclusion that they are the owners? Because Basanta Nag Chaudhary, if land belongs to Basanta Nag Chaudhary had other sons, other legal heirs, he admitted during cross-examination. That is why that plea was taken before the trial court, non-gender necessary party. They cannot exclusive right title and interest. This is a reverse finding. Why I am arguing before this honorable court? Because that decree present, if you prefer, the against which RSS has been preferred, it is a reversal decree. So that is why I have go through to I have to go to the evidence. Because it's a perverse. So far the issue number non-gender is of necessary parties concerned. So that is why I am submitting before this honorable court. Another substance question is to be definitely formed. I am admitting before this honorable court that this so far Benami transaction is not.
Now, according to you,
Okay.
what substantial question of law?
Now, this substance question of whether without their having any pleadings, the evidence laid can be considered. That is the we have proposed in the memo of appeal. Page number 12. Whether the evidence laid beyond the pleadings are admissible and acceptable as per section 5 of the Indian Evidence Act to decide suit or proceeding.
Now, this is not a substantial question of law. This is a settled proposition that evidence
But
beyond.
even then violating that set proposition of law, learned appellate court passed the judgment.
No, whether that can be a substantial question. Suppose there is a settled proposition of law. Which is not properly applied.
Honorable court, when there is a settled proposition of law, whether that proposition of law was accepted or considered or not considered. If the appellate court fails to consider this settled proposition of law, then how this judgment remains? It's valid.
No, suppose a settled proposition of law is not followed by appellate
Any
court
other court.
or trial court,
Trial court.
then whether that question becomes a substantial question of law
Lordship,
or whether it would lead to perversity.
definitely.
Therefore, I am asking, what is your additional substantial question of law which you propose to formulate? Because what you have already formulated, it is not
We
substantial.
propose,
No,
this section 4, Benami transaction.
no. The second substantial question of law which you have mentioned in your memo of appeal,
Lordship,
that whether the evidence laid beyond pleadings are admissible and acceptable.
Lordship.
This is not a substantial question of law.
My lord, may I repeat one thing, my lord?
Yes.
As my interference. My lord, the learned appellate court has not considered other evidence, my lord, because the suit was filed against a dead person. The person died in 1992 and they filed a suit in 2005 and got an expiry degree. So the learned appellate court held that it's a nullity.
Therefore, title suit number 143 was,
Yes. My lord,
the decree was set aside.
because this is against a dead person, it has been held nullity. Naturally, my lord, against a dead person cannot have a decree, my lord. The person died in 1992 and they filed a suit in 2005 against that person. Only this is a question, no other document, my lord, nothing, no facts are necessary. What my lord is saying, my lord, these facts are not necessary at all.
No, his submission is that this fact that the,
No, we have laid evidence, my lord, this fact is, so far our case is concerned, we have laid evidence when the grandfather died, when father died, everything we have said in this one evidence, my lord. That is not the facts, my lord. That need not be treated.
oh,
Because it's a suit filed against a dead person. It is known to them, my lord, that Nagendranath Chaudhary died in 1992 and Harindranath Chaudhary died in 1994.
yes, no, his submission, I will come to you again. His submission is that this fact that they died prior to fire, it was not pleaded in your title suit number 87.
My lord,
And evidence was adduced. Therefore, that evidence is not admissible. That is his submission.
my lord, I think, my lord, the person, otherwise also, my lord, the person, whether he's a person living or dead, my lord, the decree, first thing, my lord, they have to make a party who is a living person. Here, they nothing there, my lord. Here, they have made a this in the tenth, my lord, they have made a party. Nagendranath, Basanto Nag. Basanto Nag, he has been added as a party in the suit and the decree is in the appeal. So automatically, my lord, in the suit,
Okay, let him complete. How much time you will take?
could not have started, could not have started
No,
summons.
there is no issue. Your only case is that you are not pressing the first one. Second one is that there is no pleading in the title suit number 87 to the effect that the defendants in title suit number 143 already died. You filed suit against dead person.
It is their case,
It is their case, but
But
they
it's
have,
not in
they have not pleaded so,
not pleaded
but have adduced evidence to prove that fact.
before the appellate court.
So the question is whether without pleading, by adducing additional evidence during appellate stage, that can be taken into consideration. And if it is taken into consideration, whether it is perverse. That is the,
Pervert. Pervert, so far the perverse part is concerned is regarding non-gender. Because when there is an admission, from the plaintiff side, that Basantanak Chaudhary died leaving his other legal heirs. But their claim is that Basanta, the other heirs,
Presently, who is in possession of
we
this?
are. The respondents.
Permissive
That-
occupier, my lord.
All right, permissive occupier, where from they are submitting from the plain, that is why I am trying to read it out. Where from it reveals that we are the permissive occupier, since when? Learned appellate court comes to conclusion we are the permissive occupier, since when? So that is why judgments to be read out. Because the learned appellate court himself come to conclusion that exhibit 1 relinquishment is not a valid deed. If it is not a valid deed, then land belongs to Basantanak Chaudhary. If it is Basantanak belongs to Basantanak Chaudhary, the other heirs is entitled, whether they have made parties.
Then why have you not formulated that question in your memo of appeal?
Before this,
Before this
we have
court.
come
Where?
non-gender plea, we have taken.
No, substantial question of law.
Substantial question of law that was not formulated. So that is why when the formulated, only one question has been formulated, it has been observed that the appellants are at liberty to frame any other substantial question of law. So that is why I am arguing before this honorable court.
But the law is, appellant is not at liberty. Law is that court is at liberty.
Court is liberty.
And you have to formulate substantial question of law in your memo of appeal. In memo of appeal, you have not whispered anything about non-joinder of party.
Lordship, I am coming to that. Lordship. Ground number 5 of memo of appeal.
The ground is different.
From the grounds, from the memo of appeal to the substantial question of law formulated.
No, in the second appeal, grounds are not
Not
important.
taken into consideration, but whether we have taken the plea or not. Because that plea was taken in trial court. That plea was taken in the first appellate court.
No, I am not on that.
Lordship.
In a regular second appeal,
Lordship.
appeal has to be heard only on the question of substantial
Substantial question of law.
question of law. And you have already formulated 2 substantial question of law, of which court choose to formulate 1, which you are not pressing. Because court granted you liberty by an earlier order that an additional substantial question of law may be formulated. So you cannot bring out something from which is not there in your memo of appeal.
Lordship. So there is a memo of appeal. We have taken the plea, but this is not specifically mentioned. These are the substantial question of law. When the liberty has been granted, we will be allowed to formulate, I will submit that substantial question of law. Because we have taken the plea in the memo of appeal. So it may be liberty may be given to me, Lordship, the appellant, so that whether that will be considered by the honorable court or not, that liberty may be given, because by that order liberty was given.
Okay, what do you propose? What
The other 2.
what other additional substantial question of law? Because he may argue that these substantial question of law are not there. So unless you propose.
Let the matter may be fixed on another, within 2 or 3 days, we can propose it.
Yes,
Yes.
Mr.
2 or 3 days.
My lord, my humble submission is this, my lord. There are 2 substantial question law has been formulated by them, my lord.
In the memo of
The
appeal.
first question goes, my lord. The second question, your lordship may consider, my lord, only. No
What's-
new, my lord, question can,
Yes,
the
but
second question, my lord, your lordship may consider.
second question is not, if we read it plainly, it is not a substantial question of law. It is a settled proposition of law.
Yes.
That there cannot be proof beyond pleading. So that also goes,
Yes.
then nothing remains in
Nothing
this.
remains, my lord, how they can argue? They cannot argue. The other, let 2 or 3 days time, your lordship, I may propose. Your lordship, my lord, your lordship may modify the second substance question of what is can answer.
Yes,
But,
it can be modified, but for that, something has to be proposed in draft form.
Your lordship
Or
can-
you can
No. that-
argue
that-
also.
It is a court's.
Orally, yes, it's
court's
actually court's prerogative.
Court's prerogative. Substance question is always.
If
court's
it finds that there are materials
Yes.
that additional substantial question of law needs to be framed, it may frame.
So that is why, lordship, I have to go through the judgment, lordship, I have to.
I do not understand, my lord, I see.
Before going through judgment, you have to propose that this substantial question of law is there.
So I submit to propose.
You have to propose first that this substantial,
Lordship.
and to substantiate that, you may make your submission.
Lordship.
Thereafter, if the court finds that it is involved, it will formulate,
Lordship.
otherwise not. And the other side may submit that this substantial question of law is not involved.
Lordship.
Heard. I'm giving some time.
Lordship.
Heard Mr. R.K. Bhuya, learned counsel for the appellants. Also heard Mr. G.N. Sahewala, learned senior counsel assisted by Miss S. Todi, and Mr. M.H. Rajgor Bhuya, appearing for all the respondents. It appears from order dated 21/5/2014, court had formulated following substantial question of law within inverted comma, whether the suit of the plaintiff is barred under section 4 within bracket 1 of the Benami Transaction within bracket Prohibition Act 1988, 1988 question mark. Learned counsel for the appellant has fairly submitted that in view of the judgment of the apex court passed in the case of R. Rajagopal Reddy versus Padmini, in this Padmini what?
1996. 1996 SC 238.
Padmini reported in
My lord, I'm just giving my lord. Your lordship Moses. Full name may be given. That's the associate.
Padmini Shekharan, within bracket dead by LR, reported in 1995 to SCC 630. The aforestated question of law no longer remains a substantial question, as the legal position in respect of the aforesaid substantial question of law has already been settled by the apex court in the said judgment. Mr. G.N. Sahewala, learned senior counsel appearing for respondent, also submits similarly that in view of the aforesaid apex court judgment, the substantial question of law formulated by this court on 21/5/2014 no longer remains a substantial question of law not decided by the apex court. Stop. However, learned counsel for the appellant has submitted that while formulating the aforesaid substantial question of law, this court also granted liberty to the appellants to raise any other substantial question of law involved in this appeal. He submits that there are other substantial question of law which are involved in this appeal and seeks some time to submit draft substantial question of law which may be formulated in this appeal. The prayer is allowed. Let this matter be listed when fixed date.
Anytime, my lord, Thursday, my lord. The day after tomorrow.
Thursday get your school. Or when you come no. Thursday get your school. They want to subway. Next week, next week any date.
Next week, no. Next to next week, 30, Thursday. Let it be on a Thursday, hearing day. 30 October. List accordingly.
Last week.
Please, your lordship. Your lordship, in the morning, my senior Mr. A. Somo has made a mention before your lordship. In the
Oh,
last occasion,
yes. They prayed for an adjournment. You should have informed the other side.
lordship,
Yeah.
don't have the communication. We have been newly engaged in this.
Lordship,
department.
repeated adjournments have been taken in this case, Your Lordship.
No, he made a mention in the morning that he has been newly engaged.
Previous occasion also that was, this is reflected in the order sheet.
Yes, your lordship, in the
And it
last
was
occasion.
fixed today.
Your lordship,
It will record there.
we sought some time for the reconstruction of the brief, your lordship. And we have sought the same from the department. And they're going to provide us in a day or two, your lordship. Your lordship, a last accommodation may be come to us.
Prior to that, there were non-appearance, they were not appearing.
Okay. Heard Mr.
Y.N. Mohanta, your lordship.
B.
Y.N. Mohanta.
Y.N. Mahanta appearing on behalf of Mr.
H.
A. Samoa, learned counsel for the appellant, who seeks an adjournment on the ground that what is your ground?
Your lordship, for the reconstruction of the brief, we haven't received it. yet.
That they have recently received they have been engaged in this case newly and need some time for reconstruction of the brief. On the other hand, Mr. B.J. Mukherjee has opposed the prayer for adjournment on the ground that on last occasion also the counsel for the appellants sought adjournment on the almost on the same ground and said adjournment was allowed. I have considered the submissions made by learned counsel for both sides. It appears that on last occasion also the appellants took adjournment on the same ground. Stop. However, considering the submissions made by learned counsel for the petitioner, appellant, as well as facts of this case, one more adjournment is granted to the petition, to the appellants. Let this matter be listed After how much time?
Your Lordship, 2 weeks.
Lordship, preferably on a date fixed.
No, no.
Hearing date, yes.
After 2 weeks on a date to be fixed by registry.
If it is fixed by this honorable court.
No, then everything will become topsy-turvy. If it does not get listed after 2 weeks, you may make mention. Meeting.
Chief, I'm praying for an adjournment because I did not see the case. I have informed Mr. SP Chaudhary Lordship after coming to.
Miss R.D. Majumdar, learned counsel for the appellant, who prays for an adjournment due to some personal urgent grounds. Miss
B Devi Lordship on behalf of Mr.
P.
SP.
Devi, appearing on behalf of Mr. S.P. Chaudhary, learned counsel for respondent number 1, does not raise any objection to the prayer. Hence, prayer is allowed. Let this matter be listed.
On 4th November.
No,
Lordship.
no fixed date.
2 weeks.
After 2 weeks on a date to be fixed by registry.
Date of report.
May it please your Lordship. Lordship, this appeal is filed by the insurance company Lordship. Against the judgment passed by the learned member.
Just a
City Lordship.
Just a तो आगोल जी अपनी हम लोग आके दुनिया में जिस है तात लगाए. Yes, please.
Lordship, this appeal is filed with the insurance company Lordship. Against the judgment dated 17/1/15 passed by the learned member Motor Accident Claims Tribunal Sonitpur Lordship. Here Lordship, the case of the claimant was death Lordship, while the deceased, the husband of the claimant Lordship, while he was proceeding by riding a motorcycle Lordship, while proceeding a motorcycle along with his pillion rider, a bus, night super bus, dashed against it, the motorcycle, and as a result, he sustained, the pillion rider sustained injury, and the deceased, the husband of the claimant, died Lordship. And accordingly, police case was registered Lordship, and police, after doing investigation Lordship, submitted the final report Lordship, stating the fact that after investigation, that Lordship, the deceased who was riding the motorcycle Lordship, after consuming alcohol Lordship without having any helmet, he, while trying to overtake a other vehicle, it could not control his bike motorcycle Lordship. I mean, that's against the past Lordship. That is the final report. That is the finding of the police Lordship. That is, and it is also stated that there is no negligence driving on the part of the bus, the insurer of the appellant. We are the appellant, we are the insurer of the bus. There was no negligence on the part of the bus Lordship. That is a clear finding. But the learned member Lordship, without considering this vital evidence, without assessing any value, without giving any value to that final report Lordship, purposely came to finding that Lordship, the accident caused due to the negligence of the bus Lordship, and accordingly awarded the entire compensation against the insurer of the bus Lordship. This is the Lordship, a brief case of this case Lordship appeal. I will take your Lordship to the judgment of the tribunal Lordship. It starts with Lordship, page number 10 of the memo of appeal. May I read, Lord?
Yes.
The instant claim petition has been filed by the claimant under section 163 of Motor Vehicle Act, claiming compensation for the death of Digonto Millie, the deceased, who was the husband of the claimant number 1, son of the claimant, brother of the claimant number 3 and 4. The case of the claimant in brief is that on 19/3/2012 at about 11:30 p.m., Digonto Millie, since deceased, 11:30 p.m., was proceeding along with Rajesh Noro on motorcycle number so-and-so. By riding the said motorcycle, suddenly the night super bus bearing number so-and-so, which was proceeding from Lakhimpur side towards Guwahati, hit the motorcycle on NH 52 near Javaroli Forest Gate. In the said accident, Digonto Millie died on the spot. It has been further stated that
Rajesh Noro sustained grievous injuries and was brought to Dholabil Civil Hospital. Accident has been attributed to the Russian negligent driving of the said bus. The opposite party number 1, opposite party number 2, owner and driver of the super bus, filed a written statement denying that the vehicle was driven in a rash and negligent manner by the OP number 2. It has been stated that the OP number 2 had a valid driving license, being DL number so and so, valid up to 18/3/13.
Who is the opposite party number 2?
Owner
Drive.
and driver of the bus.
Okay.
They have stated, they have filed written statement and denied the negligence driving on the part of the driver of the bus. They have specifically denied.
Yes.
It has been stated that the OP number 2 had a valid driving license, being DL number so and so, valid up to 18/3/13. It has been further stated that liability arising of the said accident, if there be any, ought to be borne by OP number 3, with which the said vehicle was insured by policy number so and so, valid up to so and so. The OP number 1 and 2 have placed on record copies of registration certificate, fitness certificate, permit, pollution certificate, insurance policy, and driving license of OP number 2. The OP number 3, the insurer of the super bus number so and so, it is in its written statement denied all the materials averment of the claim petition and pleaded inter alia that the amount of compensation claimed by the petition is highly exaggerated and speculative. It has been stated that the insurer is not liable to pay any compensation until and unless it is proved that the driver of an vehicle has valid driving license and the conditions of insurance policy were not violated by the insurer. On the basis of the pleadings, the following issues were framed for adjudication: whether the victim, late Digonto Mili, died as a result of the injuries sustained by him in the LS road accident dated 19/3/12 involving the vehicle number Superbus, and whether the said accident took place due to rash and negligent driving by the driver of the offending vehicle. Whether the claimant is entitled to get any compensation, and if yes, to what extent and by whom amongst the opposite parties the said compensation amount is payable. During inquiry, the claimant number 1, wife of the deceased, examined herself, and he was extensively cross-examined by the OP number 3. The contesting respondent adduced the evidence of his investigating support of its plea. I have carefully perused the entire materials brought on record, heard both sides, and both the issues are taken up together for discussion and decision for the sake of convenience and brevity. Evidence of the claimant number 1 is that Digonto Mili died due to the rash and negligence of the OP number 2 in the road accident on 19/3/2012. It has been stated that at the time of accident, the deceased was a professional driver and his monthly income was ₹3,300 per month. The claimant number 1 exhibited the accident information report as Exhibit 1, FIR as Exhibit 2, PM report as Exhibit 3. The claimant has also submitted the copy of driving license of Digonto Mili since deceased. In cross-examination, CW1 denied that at the time of accident, her husband had consumed alcohol and the accident occurred because of his negligence. CW1 denied that the police had reported that since the rider of motorcycle was riding without a helmet after consuming alcohol, he met with an accident with a superbus while trying to overtake another vehicle. Exhibit 1, the accident information report, wherein it has been recorded that the superbus number so-and-so was involved in an accident on 19/3/12 in which Digonto Mili died. Exhibit 2 is the FIR lodged by the younger brother of the deceased after the accident, on the basis of which Jamuguri PS case number was registered. DW1 Sri Girindra Prasad Bora deposed that he was appointed by the Oriental Insurance Company Limited to inquire and collect the relevant papers and documents with regard to the accident at hand. DW1 stated that after his investigation, he submitted a report to the insurance company. DW1 exhibited the report as 1, Exhibit 1, Accident Information Report 2, FIR Exhibit 3, Seizure List Exhibit 4, MBI Report Exhibit 5, and Final Report Exhibit 6. This is the main document, Exhibit 6. Exhibit 6 is the final report submitted by the police in respect of GI case number 639/12, arising out of the FIR number 29/12. In the final report, it has been stated that the accident occurred because the rider of the motorcycle, Digonto Mili, since deceased was driving the motorcycle after consuming alcohol, and there was a head-on collision between the motorcycle and the bus. And relying on the final report submitted in Jamuguri PS case number so-and-so, corresponding GI case number so-and-so, learned counsel for the insurance company submitted that there was no negligence on the part of the driver of the bus. And the accident occurred because of the fact that Digontamili was driving the motorcycle after consuming alcohol. Hence, the learned counsel submitted that the insurer of the bus was not liable to in the instant case. Learned counsel for the claimant, relying on the judgment of Honorable Orissa High Court reported in Division Manager so-and-so, Orissa submitted Exhibit 6 of no consequence as respondents have not laid evidence of the investigating officer who preferred Exhibit 6. In the said case, Kotaris was knocked down by that is relied on by the Orissa High Court Lordship. Then Lordship, one Andhra Pradesh High Court also relied on by the learned tribunal, and ultimately Lordship, the finding is that Lordship will find next page number 15. And in the instant case 2, the quantity of alleged alcohol in the body of the disease is conspicuously missing in the final report. Exhibit 6 does not mention whether the actual extent of alcohol in the blood exceeded in the permissible limit of 30 mg per 100 liters, so as to make the rider incapable of exercising proper control over the vehicle as contemplated under Section 185 of MV Act. Neither is there any mention of the same in the post-mortem report. DW1 merely placed a copy of the report on the record. The investigating officer who prepared and filed the finding was examined in the case as an eyewitness. Thus, in view of the judgment in G. Ramulu versus DM National Supra, this tribunal has no hesitation to rejecting submission advanced by the learned counsel for the insurance company, and to the effect that OP number 3 is not liable to indemnify the owner of the offending vehicle, super bus number, as the rider of the motorcycle was negligent. Considering the evidence on its entirety, it is held that Digontamili died in a motor vehicle accident due to rash and negligent driving of the offending vehicle, super bus number so-and-so. This is the purpose finding, Lordship. Then Lordship, accordingly, the quantum was assessed. This is as per Soila Verma.
Why
As
it
per
is
the-
perverse?
yes, as per the judgment, Lordship. Next paragraph, Lordship.
Yes.
As per the judgment of the Honorable Supreme Court, this is multiplied to be applied for competing compensation depend on the age of the disease. The age of the disease 20 years, accordingly multiplied 17 was taken, and 3,300 per month. In absence of any cogent proof, the regard to the same, this tribunal inclined to accept 3,000 as income of the disease. And considering the decision of Honorable Supreme Court, Santosh Devi versus Nacharan Rajesh versus Rajbir Singh, the relying on the same aforesaid judgments, Lordship, of the Honorable Supreme Court claimant in the instant case is intended to get 50% increase towards future prospect. The annual income of the disease thus computed 54,000, and then the disease left behind his wife, mother, and siblings. Since the siblings are measured for the purpose of computing the number of dependents, his wife and his mother are held to be his dependents as per the ratio laid down Soila Verma. 1/3 is to be deducted towards the personal expenses of the disease. Thus, so deduction, the annual income of the disease assesses 36,000. And accordingly, considering the all these things, awarded the compensation of loss of dependency at 6,12,000. Lordship, then loss of consortium 1 lakh, funeral expenses 25,000, total 7,37,000. And in view of the discussion aforesaid, the opposite party number Oriental Insurance Company is to limited is directed to pay the awarded amount, Lordship. And award as for rupees 7,37,000 along with interest 7.5% from the date of filing of the claim petition till payment to the claimant. And out of the total amount is to be disbursed in the name of claimant number 2. And these are the apportionment of the Lordship awarded amount. So here, Lordship, our plea that Lordship, our main ground is that Lordship, the exhibit, Lordship, exhibit 6, the final report, Lordship, may kindly see page 40 of LCR, Lordship, Lower Court report, Lordship. And surprisingly, Lordship, there was no cross-examination.
NCR sir.
And Lordship, there was no cross-examination of the defense witness, Lordship. Lordship will find the DW Lordship defense witness at page 23.
Yes.
Your Lordship exhibited, this is defense witness, Lordship at page 23, Lordship got it.
Yes.
Your Lordship, the Girinder Nath Bora, that I am the insurance investigator, and he has also exhibited that I have collected the certified copies of police case, PS case number 29 of 12, where police has submitted the final report, Lordship, next page. Paragraph number 4, that on notification of final report, it was proved that the driver of the super bus number so and so has got no any fault. The driver of the motorcycle, Hero Honda, rashly and negligently dashed the bus at the time of accident. And accordingly, these are the exhibit, accident information report, exhibit 2, investigation report 1, 2, then FR 3, then seizure list 4, MBA report, exhibit 6, final report, Lordship. That exhibit 6, Lordship will find at page 40.
Yes.
Page number 11, Lordship.
11 of,
Exhibit 6, Lordship, the final report, Lordship. The findings,
yes.
Lordship, second paragraph, Todonto Kalot, Lordship.
Yes.
May I read, Lordship?
Yes.
তদন্ত কালত ঘটনাস্থলী পৰিদৰ্শন কৰি মৃতকৰ যাৱতীয় কাম সম্পাদন কৰি দুৰ্ঘটনাগ্ৰস্ত বাছ মটৰচাইকেল নথিপত্ৰ জব্দ কৰি যান্ত্ৰিক পৰীক্ষা কৰোৱাই বাছ মটৰচাইকেল তথা নথিপত্ৰ সংশ্লিষ্ট মালিকক জিম্মাত দিয়া জখমী ডাক্তৰী পৰীক্ষা কৰাই প্ৰতিবেদন পোৱা হৈছে। লগতে পদকীয়া বাছ চালকক গ্ৰেপ্তাৰ কৰি জামিন দিয়া হৈছে। তদন্ত কালত সাক্ষীবাদী তথা জবানী কুটকুচ কৰি জানিব পৰা যায় যে যোৱা 19/3/12 তাৰিখে ৰাতি 11 মান বজাত দিগন্ত মিলিয়ে লগত শ্ৰী ৰাজেশ নৰহক লগত লৈ ৰাজেশ নৰহৰ পিতা শ্ৰী এমেশ্বৰ নৰহৰ নামত থকা AS 12G3098 হিৰো হণ্ডা গ্লেমাৰ মটৰচাইকেলখন হেলমেট পৰিধান নকৰি তীব্ৰ বেগেৰে অসাৱধানভাৱে চলাই আহি থকা অৱস্থাত জামুগুৰি ফৰেষ্ট গেটৰ সন্মুখত 52 নং ৰাষ্ট্ৰীয় ঘাইপথৰ ওপৰত লখিমপুৰৰ ফালৰ পৰা গুৱাহাটী অভিমুখে আহি থকা নাইট ছুপাৰ বাছ নম্বৰ NL 05-120971 খন নিজ চাইডেৰে আহি থকা অৱস্থাত বাছখন নিজ চাইডেৰে আহি আছিলে। নিজ চাইডেৰে আহি থকা অৱস্থাত মটৰ চাইকেলৰ চালক দিগন্ত মিলিয়ে পুৰাৰ নিচাত একে দিশেৰে জামুগুৰিৰ ফালে গৈ থকা আন এখন গাড়ীক অতিক্ৰম কৰিব যাওঁতে নিয়ন্ত্ৰণ হেৰাই বিপৰীত দিশেৰে আহি থকা নাইট ছুপাৰ বাছখনক নিজে গৈ মুখামুখি খুন্দা মৰাৰ ফলত দুৰ্ঘটনা সংঘটিত হৈ চালক দিগন্ত মিলিৰ মৃত্যু হয়। পিছফালে বহি থকা ৰাজেশ নৰহৰ সাধাৰণ জখম হয় বুলি তদন্তকালত জানিব পৰা গৈছে। গতিকে দেখা যায় যে এই দুৰ্ঘটনাৰ বাছ চালকৰ কোনো দুখ নাই। ঘটনাটো অতিকৈ আকস্মিক আৰু দুৰ্ভাগ্যজনক দুৰ্ঘটনা। গতিকে গোচৰটো আইনৰ 279 ধাৰাত আকস্মিক দুৰ্ঘটনা বিবেচনা কৰি চূড়ান্ত প্ৰতিবেদন দাখিল কৰা হ'ল। নাইট চুপাৰ বাছৰ চালকৰ এই গোচৰৰ পৰা অব্যাহতি দিয়াৰ বাবে প্ৰাৰ্থনা জনালো। গোচৰ তদন্তৰ ফলাফল গোচৰীয়াক জনাই দিয়া হ'ল। চূড়ান্ত প্ৰতিবেদনৰ লগত তিনিখন Lordship, this is the final report, Lordship. As per this report, Lordship, there is no negligence driving on the part of the bus.
But this final report was prepared by a different person who is the investigating officer, who was not examined as a witness. And on that ground, this final report was not taken into consideration by the.
It is correct, Lordship, but the thing is
On
there
that,
was-
what is your submission? Where the tribunal went wrong?
Lordship, this is a certified copy of it's a public document, Lordship, certified copy of the final report, Lordship.
So your submission is that even without examination of investigating officer, final report may be relied upon. Is that your submission?
That is my submission to some extent, because Lordship, at that time, our investigator has proved this before the learned tribunal. The issuing authority was not before the tribunal.
But investigator has not conducted the investigation. Investigation
That is
was done by a police officer. And the tribunal rejected your submissions before the
Yes.
trial court merely on that ground, because, and secondly, the content of alcohol in the blood of the.
But on that ground, no cross-examination to that extent. They have not objected this report, Lordship.
No,
There
they
is
may
no
not,
objection.
there may not be any objection, but that does not mean that court will admit something which may be inadmissible, or court may rely upon something which is unreliable.
Lordship, this is the report, but there is no eyewitness to that extent. Even if it is not accepted, Lordship, but there is no eyewitness to prove that it is only the bus who, due to negligence driving, the accident took place. There is no evidence to that extent. No eyewitness was examined, Lordship. Only the claimant, the wife, who has not seen the accident. No one is before the tribunal to prove. Even the FIR who lost the FIR is also not before the tribunal. So they have failed to prove the fact, Lordship, that due to the sole negligence of the bus, the accident took place, Lordship. And if Lordship will see the MBI report they have exhibited, Lordship. This is, Lordship will find the MBI reports.
The FR is exhibited as Exhibit 6.
Yes, Lordship. And MBI report is 5, Exhibit 5. Page 39, Lordship will find.
Thirty-nine of the.
39, lot of the
Appeal
law
memo.
court record, page 39, MBI report of the motorcycle, page 38, sorry, MBI report, page 38. Law court record. Original and photocopy both are there, Lordship. Original is at page 38.
Yes. What do you want to show?
Lordship, motorcycle, the damage of motorcycle, Lordship. Lordship, may kindly see the damages. He hit the bus, Lordship, the front side damage.
The damages may also be
These are the
found
damages.
if the bus hit the motorcycle. If it is otherwise wrong, you are saying that there is no eyewitness.
There was no eyewitness before the tribunal. No eyewitness. He is the claimant who has not seen the accident.
Then on what basis It is said that the motorcyclist hit the,
Because lordship, head-on collision, this claimant lordship, the FIR has said it collided with both the vehicles. Both the vehicles collided, lordship.
there has to be collision in an accident.
Yes, lordship. But the thing is that lordship, if we not accept this also lordship, the final report also, then also the facts comes lordship from circumstantial evidence. They have stated that due to sole negligence, the tribunal held that due to sole negligence. How it can, lordship? There was no evidence to that extent. Lordship. Sole negligence, there is no evidence, lordship. No direct eyewitness, lordship. And cross also claimant could not say anything, lordship.
Okay. Anything else?
Lordship. This is the main point, lordship. If lordship consider this point that even in absence of eyewitness, lordship, that can be held, lordship. When two vehicles are involved in the accident, unless it is proved that only the bus is negligent in causing the accident, then lordship, both the vehicles should be made liable, lordship. And they have not made the party the other insurance company, lordship, but their insurance company policy is not valid at the time of accident. Therefore, they did not make the party the other side, other insurance company. From the MBA report, lordship, it appears there was no policy already lapsed, lordship. That's why they did not make the
Policy of motorcycle.
motorcycle, lordship. That is there in the MBA report. It appears, lordship. Exhibit 5, lordship.
Motorcycle belong to some third person.
Yes. Third person, even then, lordship, he was riding
He's not the
the motorcycle. Exhibit 5, lordship, may kindly see.
Okay. Anything else?
This is, lordship, may kindly see exhibit 6, lordship. Exhibit 4, lordship. Exhibit 4, page 36. Seizure list. Exhibit 4, page 36.
Yes.
Lordship, paragraph 3, lordship, paragraph 3. One original two-wheeler. Lordship,
Yes.
one original two-wheeler certificate cum policy schedule of National Insurance Company Limited of vehicle number so valid from 15 to 2011 to midnight 14 to 2012. Whereas lordship accident took place on lordship 19/3/2012. There was no valid policy at the time of accident. Since lordship, the evidence, the claimant said that due to, in the FIR also, collision of both the vehicles is there, lordship. That is not denied. Admitted fact that collision of both the vehicles, the accident took place. Therefore, lordship, Unless there is a positive evidence that due to sole negligence of the bus, it happens, the contribution of both the vehicles should be there.
Okay,
I may be allowed to reply, Lordship.
yes, Mr. Bhattacharya.
May I please, Your Lordship. My lord, from the memo appeal, it seems they have taken two grounds. One is that appeal is based on the final report submitted by the police. Another is that he was a drunk. These are the two.
Another is, next is
Next is measure that he was drunk.
drunk.
These are the only two grounds they have basically taken. No, my lord, so far the police report is concerned. There's a second rider is also there. Rajat Noro, who was the pillion rider. He also approached this court insurance company on the same grounds. So I could have passed an order. Your lordship will come to paragraph 9, 30, 14. Because he was the pillion rider. In that case, he has given the evidence. So my learned sister who has submitted, there is no evidence. Wrong. Because Rajat Noro in this appeal has reduced the evidence that he was injured and his police was dead. So your lordship, this came into consideration. Now the next question is come.
Rajat Naro adduced evidence in
his case.
In his
case only.
Not in this case. In this case, I just stated the facts. My lord, your lordship will call the record and you find it. Is there. Now.
But how it will help you?
My lord, he stated that this person has died on the spot. He has stated the accident because he was alive. He was taken to the hospital.
But you have not brought that evidence in this case.
When one evidence is already there in similar matter, it already comes back. Because in the same court judgment, corroboration is there. The record, if your lordship call the record of that case matter, is there. Now I am coming to the next point, my lord, about the police report. Now, if your lordship, that the police report is so biased, my lord, I will tell you. Your lordship will come to the exhibit 1, page 25, if I'm 24, no, 25. Then your lordship police report, column 8. Page number 27. Exhibit 1. Investigation report, my lord, submitted by the insurance company. The lordship got it.
Yes.
The lordship got it?
Yes.
Madam, my lord, paragraph 8. As per the police report, it is found that on 19/3/12 and about 11:30 am, while Mr. Diganta Mili and Rajesh Noho was proceeding towards the home at Khanamo by motorcycle, at that time, a speeding bus, so and so, knocked down at the near Japori Guli Forest Gate number so and so. As a result, both the motorcyclists sustained grievous multiple injuries. Due to that, Diganta Mili died on spot. As per the police report, the accident occurred due to the rash and negligent driving by the bus driver. This is one report, my lord. But in the final report, they say he is drunk. And the postmortem report did not reveal anything about any alcohol. Your lordship must kindly note this. This is a manipulated final report. They have done it, my lord. I submit it on authority, my lord. It is the report of their document, my lord.
And in the postmortem report, there was no finding that the man was consuming any alcohol. And the trial court has rightly invoked the section 187, because when there's a drunken accident is there, it has to establish what was the percentage of alcohol he has consumed. The tribal people do consume, I don't say no, but what is the extent of? Because I will give a citation of the Supreme Court on this ground, my lord. So these are the basically ground she has taken on this insurance company, the drunken and accident. This report shows that it is a negligence of the driver. So this shows that negligence. So far the FI is concerned, whether the criminal proceeding has any impact on the motor vehicle tribunal matter. Yeah. 23. My lord, I have given the full decision of the Supreme Court of 2023 and 22. I'll just read the headline, my lord, paragraph 9 and 10 of 2023, my lord, library. So far as claim petition by the appellant here is concerned, the less negligence on the part of the driver.
Which judgment you are reading?
2023, my lord, it is Supreme Court Criminal Appeal. Number M.V. Nagatham, Justice, Honorable Justice and Pasanta Kumar Misra. 2023 INS 621.
Matthew Alexander.
My lord? Yes. Matthew Alexander. Para 9 and 10.
What you want to submit?
The final report, the first title itself says, my lord, the final report in the criminal investigation connected to the accident would not have a bearing on the claim petition, and that claim petition must be considered on its own merit. Now, there, please, that police report. Police report is nothing to do with this matter. That is the submission given by the apex court has laid down the law. It has to be this own merit. And our High Court also, my lord justice, that I have placed, my lord, that is also there. Already Justice Seki has stated that in the paragraph 13, my lord. Already stated. Our High Court judgment also. That criminality FIR police report has nothing to do with the HOV, it doesn't decide its own merit. These are the two judgments, my lord, on the basis of the now the drunken matter. So for the drunken is concerned, my lord. Okay. Finally, the recent judgment. Yes. It is recent judgment of the Kerala High Court, my lord. The big judgment, my lord. Kerala High Court, my lord. My lord, it will come from paragraph 7.1. Because it has stated as per the Supreme Court that if there is any consumption that should be reflected in the postmortem report, what is the percentage and all. Nothing is there, my lord. The para 7 onwards, my lord, your lordship will find in para 7, then your lordship will 23, 34, my lord. Lot of decisions are there, my lord. 23, 34. Then 36, my lord. 19.
What do you want to say through this judgment?
Because I want to say, my lord, the person was not drunk. And insurance company has failed to prove that he was drunk. There is no report in the postmortem report that he was drunk and what is, even in the police report, what is the quantity is not there. Because that report is biased on which my learned friend is based. There is no single line. What was the quantity of alcohol he has consumed? What is the percentage? That is the 186 MB Act has clearly stated that. It have to be stated. What is the percentage?
What is there in 187?
One good. MB Act. Because this Kerala judgment has narrated this section, my lord.
Please read one.
Yes, yes. One 85, my lord. Driving by a drunken person or by a person under the influence of drug. Your lordship got it.
Yes.
Whoever, while driving or attempt to drive a motor vehicle, has in his blood alcohol exceeding 30 mg per 100 milliliter of blood detected on the test by the breath analyzer, or if he is under the influence of drugs which extend to the extent as to be incapable of exercising proper control of the vehicle, shall be punishable for a first offense with the imprisonment term which may extend to 6 months or which may be extended to 2,000 and extended this committed within the 3 years of the commission of the previous crime, and mean imprisonment for term which may extend to 2 years and fine. If for the purpose of this action, the drugs and that specified in the central government on behalf of the motor vehicle official shall be tendered a person incapable of exercising the proper control over the Motor Vehicle Act. So, my lord, it has to be specified what was the quantity of. Until and unless the report shows that what percentage he has consumed, it cannot be said this was driving matter drug. And the post-mortem report doesn't reveal anything about the drugs. So their contention of the police report, which I have shown, first thing they said it is the driver. Next one, in the final report it submitted, it says no, it is not the negligence of the driver, he was drunk. What was the percentage of drunk? And the tribunal has rightly stated in the judgment. The tribunal rightly stated in the judgment. Stated in the judgment, my lord. 14, my lord, page 14. Exhibit C, the final report, which has been considered by the. Yeah, I read, my lord. Relying on the final report.
No, judgment has already been read. You need
Yes,
not
yes,
to
yes.
read it.
It is there, my lord. In the instant case, the quantity of the alleged alcohol on the body of the deceased is compulsorily missing in the final report. So how it is perverse, my lord? They have not challenged that.
Okay.
They are solely relying on the final report. Whereas the other, I have shown that without any basis, my lord. 183 says quantity must be there. That's Kerala judgment which I placed, my lord. It is elaborately stated there. And the postmortem report, which is 48 exhibit, my lord. LCR, my lord. I live in it. Doctor's opinion. In my opinion, the person died of a shock and hemorrhage as a result of injury sustained.
Okay.
There's no postmortem report about alcohol. There are 2 points they have taken. One is police. that is
Okay,
not
any
in that.
reply?
My lord.
First of all, Lordship, my senior counsel has said that accident information report, Lordship. Accident information report, if Lordship will see the accident information report, Lordship, that is at page 43. Their Lordship stated that the vehicle was night super bus, registration number of the vehicle and type of vehicle. That is, the bus registration number was reflected, Lordship. In page, Lordship will find lower court record 43. Page 43
Yes,
of lower
what do you want to say?
Lordship, here it is stated that a case has been registered, investigation is going on. This is not the final, Lordship. The involvement of the vehicle is stated here, mention is there, Lordship. The bus is mentioned, bus number is mentioned. And after the investigation, Lordship, it is found that the vehicle, the motorcycle was driven in a rash and negligent manner. That is reflected. Along with the drunk, he was consuming alcohol, Lordship. Then where is the rash and negligence driving? That is, who will prove that, Lordship? There was no eyewitness. If he is not drunk, then the other part of the allegation, other part of the finding that he was driven a rash and negligently, the motorcycle was driven by the rider of the vehicle. And then he was also drunk and without having any helmet. That is their, Lordship. And rash and negligence driving, Lordship, no eyewitness is there.
Okay.
No one. And Rajesh, so far as Rajesh is concerned, he has proved, he has given evidence in the other case, Lordship. Other cases, and that was not tagged with this, that evidence is not carried in this case, Lordship. And the claimant who has given, only the claimant, the PW1 on this, she has stated that I have not seen the accident. And she has denied the questions put by the insurance company. The other part is that my learned counsel has saying all these things, but whether there is on record, Lordship, whether there is any cross-examination done on these points, the point raised by the DW, whether they have denied that, whether they have put all these questions to the defense witness, Lordship. There is no cross-examination, cross-examination even declined.
Okay.
That amounts to acceptance, Lordship. The rash and negligence, how involvement of 2 vehicles are there. How, why, on what basis, Lordship, only the bus is made negligent, whereas the finding is that there is negligence on the part of the motorcycle. Even then, the only bus, the finding of the learned member is only the bus. That bus drove the vehicle negligence way. But what about the motorcycle? What is the finding to that extent? No witness, no evidence.
Okay, heard.
Yes, Lordship.
Miss M. Chaudhary. Learned counsel for the appellant. Also heard Mr. K. Bhattacharjee. Learned counsel for respondent number.
Respondent number 1. 1, 2, 3. Respondent number 1, 2, 3, and 4.
Respondent number 1, 2, 3, and 4.
E.
Any respondent?
1, 2, 3, and 4. Ano?
Yes. 1 to 4.
Hearing concluded, judgment reserved.
Lordship, in this case, Lordship, we have already deposited as per direction of this honorable court 50%, but that is not allowed to withdraw. That is before the registry, it's lying before the registry.
Okay. I'm reserving the judgment.
Lordship. Must oblige.
Yeah, Lordship.
Obliged. So this is an appeal, first appeal against judgment dated 22/7/2019. Was a suit for specific purpose, five was the appellant as plaintiff.
Nobody has appeared.
Earlier they appeared, but later on the learned advocate appearing for respondent when they withdrawn his wakaltama, and thereafter nobody appeared. Only my lord, my suit was a part decree on the basis, my lord, that the plaintiff appellant is a resident of Impal. So he is not entitled to the decree of sale of the land. That was the, my lord, the reason. And this finding is, my lord, not correct, my lord, because with this appeal, my lord, first appeal, my lord, in fact also can be excluded. So, my lord, if you, lordship, I will look at, my lord, page.
You were plaintiff before the trial court.
My lord.
What
My
was
lord,
your case?
my case is, my lord, that admittedly, my lord, there was an agreement for sale of one kata.
No, no. What relief you sought for before the trial court?
My lord, I sought the relief of, my lord, the specific performance of the contract for sale of the land, my lord. And my case was that, my lord, sale consideration was, my lord, 21 lakh. Out of 21 lakh, my lord, I have already paid 20,20,000, my lord. So only 80,000 was remained to be payable by me to the dependent number 1 month. And he has also, my lord, handed over the possession to me, possession of the suit claim to me, my lord. But subsequently, my lord, the defendant 2 and 3, with the help of, my lord, sub antisocial elements, they dispossessed me from the suit claim, my lord. So I made them also a party. So, and my lord, I adduced the evidence of 2 witnesses, my lord. And my witnesses duly corroborated with the statement made in the plain, my lord. The defendant also adduced, my lord, they submitted the evidence of 2-3 witnesses, but none of the witnesses turned out to, for cross-examination, my lord, and accordingly their evidence was expunged, my lord. Lord, so if I will look at page 86, my lord. Page 86 is, my lord, my voter card. So, my lord, apart from I was the, my lord, I'm permanent resident of Impal, no doubt about it, my lord. I was born and brought up in Impal, my lord. But subsequently, my lord, I shifted to Guwahati, my lord. And since, my lord, 1985-86, I'm having a flat in Artgaon area, my lord, near apartment. And I also next, my lord, the electricity bill, the GMC property tax bill, my lord, as well as my voter card. My page 86 is my my voter list, voter card. So, my lord, the finding that I am because I am otherwise also, my lord, Impal is there also in within India, my lord. So on this ground, this finding cannot be.
Where is that observation in the judgment on the basis of which your suit was dismissed?
And one more thing, my lord, we made, my lord, the payment 12 lakhs at the
No,
time.
why the trial court dismissed your case?
No, trial court did not dismiss my case. No, trial court come to the conclusion that since I am a resident of Impal, I am not entitled to the sale of land, my lord. So I am entitled to, my lord, refund of the consideration.
So refund was directed.
Refund was directed, and the refund was also, my lord, 8,20,000 less than the amount paid by me.
Okay, so you are impugning the finding that specific performance is.
My lord.
Where is that finding?
My lord, that finding is
page 75, my lord. Page 75, para 11. Married, my lord.
Yes.
Issue number 6. From the present scenario of the facts and circumstances, it appears that the plaintiff is a resident of Impal in the state of Manipur, and it shall not be possible for execution of the sale deed as well as for restoration of the khas possession of the suitland in dispute to the plaintiff. Therefore, the alternative prayer made by the plaintiff for realization of only 12 lakh as decided in issue number 2 is considered in this decree. Therefore, the plaintiff is entitled to get a decree of 12 lakh with interest at the rate of 24% from the date of institution of this suit till realization of the decree, and the decree is realizable only from dependent number 1. Dependent 2 is not at all liable in the present suit. Now, my lord, if we came to the issue number 2, my lord, regarding the payment, my lord. Married, my lord, page 73, my lord. So, my lord, this finding that I am a resident of Impal, so I am not entitled to decree is also, my lord, against the law of land, my lord, because I am a citizen of India, my lord, and I am entitled to purchase property anywhere in India. That apart, my lord, I am a resident of state of Assam, my lord. I have my name in the voter list, my lord. I submitted before the honorable court, my lord, my voter's card, my lord, that has been issued by the state of Assam, my lord, election officer Assam, my lord. So that finding is, my lord, contrary to, my lord, the law of land. I also need, my lord, page 86 in my voter card, my lord. Page, my lord, 81 is, my lord, my certificate issued by Guwahati University, my lord, at in the year, my lord, 1966. I was a student of Guwahati University, my lord. I passed my pre-university under the Guwahati University, my lord, in the year 1966, my lord. And, my lord, page 82 is, my lord,
No, why the court observed that as you are a resident of
My lord,
Manipur,
the
it shall not be
court-
possible to execution.
My lord, the learned court observed perhaps, my lord, because in the plaint, my lord, my address was given of the Impal. In the plaint, my lord, title page of plaint, my lord. Is that page, my lord, 17, my lord.
Now, whether in pursuant to the decree, you have received back money,
No, my lord. Nothing.
you have not gone for
No.
execution.
No. Because, my lord, we challenge this finding, my lord. Because money also, my lord, we paid, my lord. In fact, my lord, we deposit or after payment of this 12 lakh, my lord, we paid another 5 lakh in the account of the, my lord, dependent number 1, and thereafter on some other date, my lord, 3,50,000. So total payment we made, my lord, 20,20,000. And that is the reason, my lord,
What was decided as regards issue number 2?
as regard issue number 2, my lord, it was decided, may I read my page 73. My lord, the learned court below did not believe, my lord, the a counterfolio of the paying slip which we exhibited giving our evidence, my lord. The learned court below said that no, this money we deposited in case in the account of, my lord, dependent number 1 as per the instruction. And this was, my lord, in our evidence we have clarified why we deposited the money in case 1.
No, read findings of issue number
My
2.
lord. During the cross-examination of PW1, Pawan Kumar Sethi, the defendant could not discard the fact that dependent number 1 did not receive money from the plaintiff. In fact, to a question, PW1 specifically answered that he gave a check of rupees 4 lakh to the dependent number 1 during execution of Exhibit 1. Subsequently, he again answered that he gave rupees 8 lakh, and in total, he gave rupees 12 lakh to the dependent number 1. Therefore, the aspect relating to the payment of 12 lakh on 11/7/2011 is not disputed aspect. And this portion of the issue is decided in favor of the plaintiff. However, the plaintiff could not succeed in showing that he paid rupees 5 lakh on 2/7/2011 and rupees 3,20,000. And so these aspects are not decided in favor of the plaintiff. Now, my lord, to this fact, my lord, this finding may have a lordship to my lord, my evidence, my lord. These dates are also, my lord, not correct, my lord. I'm just taking lordship, my lordship may have a look at my lord, page 41, my lord. Page 41, my lord, and para 5. May I read, my lord?
Yes.
That I say that thereafter on 18/7/2011, the dependent number 1 approached me over mobile and requested me to deposit a further sum of rupees 5 lakh in his account number such and such with the State Bank of India on the ground that his mother, that is dependent number 2, is seriously ill and she is admitted in a hospital at Delhi. So he required money urgently for her treatment, and believing bona fide on his request, I had deposited 5 lakh in case on 18/7/2011 itself in the aforesaid account of the dependent number 1 as per his instruction. Similarly, on 22/7/2011, the dependent number 1 again requested me over mobile phone to deposit a further sum of 3 lakh into his account, aforesaid account with the State Bank of India on the ground of illness of his mother, and assured me that immediately on coming back from Delhi, he will execute the sale deed in my favor and hand over the possession of land to me. And believing bona fide on his said assurances, I again deposited a sum of rupees 3 lakh in the aforesaid account of dependent number 1 on 22/7/2011. Exhibit 8 and 9 are the counter folios of paying slip whereby I had deposited rupees 5 lakh on 18/7/2011 and rupees 3 lakh in the account of dependent number 1 with the State Bank of India wide exhibit. Exhibit 8(1) and 9(1) are the signature of bank official with the seal of the bank in token of receipt of money from me. So, my lord, the learned trial court has not noted this fact, my lord, but the date is also wrong on that. I deposited on 2/7. In fact, I deposited on 18/7 and 22/7/11. And I have exhibited, my lord, this to counterfolio of paying slip, my lord. So this finding, my lord, that I have could not succeed in proving the payment of 8,20,000 is not correct, my lord. And regarding the, my lord, the balance,
Where is your cross examination?
my lord, my cross examination is there, my lord. Type copy, my lord, starts from page 46. My lord.
As regards
these.
para 5,
My lord.
what was the cross examination?
My lord, I'm just coming. My lord. Regarding the page 48, my lord. Page 48. May I read, my lord?
In
After
exhibit 7. Yes, please read.
Exhibit 9, there was no witness. There was no witness in exhibit 9. It is not a fact that the dependent was not the owner of the land in the suit. It is not a fact that exhibit 2 is not signed by the dependent number 1. In exhibit 7 and 8, the name and signature of depositor has not been mentioned. The only question is that, my lord, the exhibit 7 and 8 are the, my lord, these paying slip. Actually, it ought to have been, my lord, exhibit 8 and 9. I have not submitted any statement of account of myself and the dependent number one, which reflects the account number. It is not a fact that I have not paid any amount of the dependent number one, except the amount of rupees 4 lakh to him. I know that for the execution of registered salary, the permission from Deputy Commissioner NOC from GMD is required, which I have not applied for. The required documents to obtain the sale permission were not demanded by the dependent number one. So I have not given the same to him. I know that the documents were required for permission. I have never asked the dependent number one to get the permission for sale of the land. It is not a fact that I have filed a false case against the defendant. So, the only question was put regarding exhibit, the paying slip, that it did not contain the accountant signature of the depositor. So, signature of deposited required on the in the copy of paying slip, which is kept by the bank.
Then how it would be proved that the money has been deposited by
Because
you?
otherwise, if I have not deposited, then otherwise the original paying slip could not be in my possession.
Okay.
And no, to that extent, no question was put up that this money was not deposited by me, or that this money was deposited by the defendant himself and he has given the paying slip to me. No such question was put to me. And even otherwise, suppose this aspect is even if then so far the agreement is not disputed, my lord. My payment of 12 lakh is not disputed, my lord. So I mean, and my lord, on the ground that since I'm a resident of Impal, I'm not in that, my lord, finding.
Yes. Okay. Heard Mr. J.C. God, learned counsel for the appellant. None has appeared for the respondent on call. On last occasion, that is on 2/9/2025 also, respondent was not found on call. And an observation was made in the said order that on the next date, that is today, if none appears for the respondent, the appeal shall be heard. Stop. Accordingly, this appeal is heard ex parte against the respondent. Hearing concluded, judgment reserved.
My lord, I'm relying on one judgment.
Yes. Judgment to press what point?
Only, my lord, that my lord, that the plaintiff in specific is only only thing that whether I was ready to make the balance payment.
Okay.
That is only to be considered.
Okay. Remaining matter would be shown as leftover.
My lord, can we get it fixed with your lordship? So please, yes. Item number 26.
Item number 26.
My lord.
26, somebody has mentioned.
Mention.
Oh, cross objection. Who is for the other side?
My brother.
What is your submission? It is for final hearing.
Final year. Say injunction matter.
No,
They are the applicant, my lord, I am the respondent.
heard Mr. S. Bishwas, learned counsel for the appellant / applicant. Also heard Mr. S.K. Singh, learned senior counsel assisted by Mr.
A. Dhanuka.
A. Dhanuka, learned counsel for respondent number 1. Due to paucity of time, this matter could not be heard today. Let this matter be listed when?
23rd. 23rd or 4th or 6th. 24th, my.
24th would be a non-hearing date.
So
Let it be on a hearing date,
on 11 November, my lord.
on
My
11
brother-
November,
But there's a stay
Only
of
10
filing
days.
11 November,
6th of.
11, please. I will have to come only for this.
on 11
There's
November,
a stay, my lord, this matter pertains to petrol pump. It has been stopped since.
I am
11
ready, my-
November,
Lordship,
Similar paper item number 22.
leftover.
Early hearing is given 5 to 11.